All right. Is counsel for the defense ready to begin the pretrial motion?
Yes, Your Honor.
All right then. Sir, whenever you're ready, you may proceed then.
May it please the court. Your Honor, the defense brings forth the motion to exclude the defendant's statements made to Officer Beaart on February 16th, which are as follows. Sure, I totally could go down there and get those documents, but I'm not responsible for Remi doing anything illegal. That could take things way too far. The defense seeks to exclude these statements on the basis of them being given prior to the defendant being read Miranda rights. Miranda rights should have been given to Ms. Croddy for two reasons. First, Ms. Croddy was in custody. Second, Ms. Croddy was the subject of an interrogation. Looking to the first standard of custody, the conversation between Croddy and Officer Beaart indicates a coercive environment in which Lee Croddy is not free to leave. The standard to test if a defendant is in custody is based on whether a reasonable person in the defendant's circumstances would believe they're free to leave. If they reasonably believe they are not free to leave, they are effectively in custody. In the case of Boyer, the defendant was transported to the police station and interrogated in the police interrogation room. Because of the coercive environment typical to such rooms that would thus diminish the voluntary nature of the defendant's statements, the court in Boyer ruled that the defendant's admission in that room was not admissible to trial. The case of Boyer is strikingly similar to the case at bar. Today, there are three facts that indicate a coercive environment. First, Croddy was made fully aware that she was in a police vehicle because of the police radio that was in use during the conversation. Second, Croddy understands that she is not going to Disneyland. She's going to the police station as a witness to a serious crime of assault on a government official, and thus reasonably could believe that she could not leave and possibly obstruct the investigation.
Well, but didn't the defendant voluntarily go?
Correct, Your Honor. The defendant did voluntarily enter the vehicle. However, the standard set by Boyer is not whether the defendant voluntarily entered the room. It is dependent on if the defendant can leave the room at will. Thus, although
what was there to prevent the defendant from leaving then, or saying, you know, I've changed my mind?
Your Honor, Lee Croddy, as a reasonable person, could not reasonably believe they can leave the car at will, because as mentioned, Lee Croddy was a witness to a serious crime of assault on a government official. Leaving the car then is essentially a reboot of the officer's investigation of the assault. Additionally, Croddy is in the back seat of the car and thus lacks authority while in the environment.
Well, how is this case different from People versus Anderson? I mean, the topic of the conversation between Officer Beaart, the defendant, was could be termed as neutral, and just related to the defendant's YouTube social media influencer status. I mean, how was that conversation designed to elicit incriminating responses?
Your Honor, the defense may concede that maybe the first question by Officer Beaart was casual. However, the moment Officer Beaart used specific phrases such as, "you have to admit," the conversation became casual and turned into interrogation, as Officer Beaart was specifically harping on the fact that Lee Croddy could have been an anarchist in an attempt to alleviate incriminating responses from the defendant.
All right, but the fact that the conversation started off with, "Aren't you that anarchist on YouTuber?" and but you have to admit, again, that just goes to his political leanings and discussion. It doesn't go towards. It's just like asking him, "Oh, I see you wearing a Dodger hat, so you're into the Dodgers. What do you think of their season and their recent trades?" I mean, how is it any different?
Your Honor, the important fact here is the fact that Lee Croddy being an anarchist isn't just their political leanings. Rather, in today's trial, Lee Croddy being an anarchist is a piece of incriminating information that the officer can reasonably string to connect Lee Croddy and Remi Montoya.
Is it incriminating, or is it just an acknowledgement that, hey, you're that guy on YouTuber and you're either the anarchist or you go by the name of Crazy Clown or whatever? Isn't that, or gee, aren't you Justin Bieber? I've seen you on YouTube. I mean, isn't it kind of along that line?
No, Your Honor. If I went up to someone and said, "You're Justin Bieber, right?" and they said, "No, I am not Justin Bieber," and then I insist, "No, you are Justin Bieber. You are Justin Bieber," that is not casual. That is trying to get that person to admit to being part of a certain group.
So the fact that you're indicating then that the quote when Officer Beaart says, quote, "whether you are an anarchist or not," and so on, that is designed to elicit an incriminating response. Is that what your thought is?
Yes, Your Honor. The
Okay,
phrases
go ahead.
you have. Thank you, Your Honor. Third, Croddy was in the back seat of the car and thus was unable to leave the vehicle at will. For these three reasons, the setting of the interrogation was clearly custodial, and Croddy made those statements in the context of a coercive environment. Onto the second standard, the conversation was an interrogation. The case of Rhode Island v. Innis defines interrogation as a conversation with the intent to elicit an incriminating response, which Lee and Bird's interaction was. Officer Bird repeatedly accused Croddy of being an anarchist. Despite Croddy's clear unease, continued to ask Croddy questions to admit to being an anarchist. Croddy clearly demonstrated the officer her unease, invoking her right to an attorney by questioning whether she needed to call for a legal counsel. Although at face value the subject of being an anarchist may seem just as Croddy's political leanings, the subject of being an anarchist directly relates to the connection between Lee Croddy and Remi Montoya.
Let me ask you a question. You're familiar with all the cases that the prosecution is going to rely on, correct?
Yes, Your Honor.
All right. Which case do you think is their best case, and how do you distinguish it from the facts in this case?
Your Honor, I would argue that none of the cases in the packet necessarily support the prosecution, as many are distinguishable in many ways. However, if I had to pick one, I would likely pick the case of People v. Torres. However, the difference between Torres and today's case is the fact that in the case of Torres, although there was a pause after the conversation, the questioning had completely ceased, and the defendant began a separate conversation. However, in today's case, Lee Croddy is still responding to the initial assertions by the officer.
But in his response, isn't he kind of switching the channel, so to speak? Okay, we go into this, hey, are you a YouTuber, anarchist guy, blah, 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 and then completely left field, switching the channel, all right? Doesn't he then offer up the type of statement that you're trying to keep out, which is, hey, look, the kid and I are not close, and so on.
Your Honor,
that's completely, that's 360, 180 from, hey, are you this anarchist guy?
Your Honor, this is not the case, as during the prior conversation, the mentioning of anarchy is a direct connection between Croddy and Montoya. And as a result, Croddy addressing this connection is simply Croddy addressing the elephant in the room. The connection between them is implicitly there in the officer's questions.
All right, go ahead.
Thank you, Your Honor. Arguably, Officer Bird was antagonizing Lee to attempt to get a rise in Lee Croddy that she was an anarchist, which then could possibly associate her with her follower, Remi Montoya, who also could have been an anarchist and frequently consumed Croddy's content. Any reasonable person will understand that Officer Bird's attempt to pin my client in the same group as Montoya, who was arrested mere moments before the conversation had taken place, was an attempt to associate Croddy to Remi. At the end of the day, it is simply impossible to prove that Lee Croddy aided and abetted Montoya's crime, absent first proving the connection between the two, which Officer Bird's questions directly aimed for. As such, Officer Bird's statements could produce an incriminating response, and thus Lee Croddy was under interrogation. For these two reasons, the conversation in question meets the standards to be labeled a custodial interrogation. Because today Officer Bird did not require his Miranda rights in this conversation, we ask the court to rule the statements in question inadmissible. Thank you.
Well, thank you very much, counsel. Appreciate the argument. People, are you ready at this time?
Yes, Your Honor.
All right, whenever you're ready.
Thank you. Miranda warnings must only be read before a custodial interrogation. However, the interaction between Officer Max Bird and the defendant, Lee Croddy, was not a custodial interrogation for two main reasons. First, the surrounding circumstances did not objectively amount to custody. And second, there was no interrogation. In the case at hand, Officer Bird was wearing plain clothes and driving an unmarked vehicle that did not even have a metal cage or a siren. After the defendant voluntarily entered this vehicle, she and Officer Bird had a conversation in which the defendant admitted to telling Mr. Montoya to, quote, go down there and get those documents.
Now, how is this any different than People versus Boyer? Because there in Boyer, the officer was plain clothes, unmarked car, officer lacked probable cause to arrest the person, and they didn't find that to be an interrogation.
People versus Boyer.
Well, excuse me, they did find that to be interrogation. So how is that any different than what you're arguing here in this case?
There are several core distinctions between People versus Boyer and this case. First of all, as you mentioned, in People versus Boyer, the defendant was arrested without any legal grounds. Whereas in this case, the defendant was not being arrested for a crime. She was merely being offered a ride to the station for questioning as a potential witness. And Officer Byrd repeatedly made it clear that he did not view her as a suspect in any crime by making statements like, "No one was accusing you of anything." Additionally, the defendant was in that vehicle voluntarily. She agreed to get into that vehicle and take a ride down to the station with Officer Byrd. She was not forced in there. These are some core distinctions between this case and People versus Boyer that are the reason why this is not a custodial interrogation.
Well, how would you differentiate this case with Rhode Island versus Ennis, where the defendant had been given his Miranda warnings, but this was a conversation between two officers, not directed necessarily at the defendant in that case?
Yes, Your Honor. In the case of Rhode Island versus Ennis, similarly, it was found to not be a custodial interrogation because the police officers were not directly questioning the defendant and trying to elicit an incriminating response. And we see a similar fact pattern in today's case. Officer Byrd did not make any statements directed at the defendant that would be reasonably likely to elicit an incriminating response.
Well, when you accuse somebody of being an anarchist, I mean, are they just supposed to sit back there and say, "No, I'm not"? I mean, can you imagine being accused of something horrendous and awful that is just not who you are or how you feel about something? I mean, and not want to just at least defend yourself and say, "No, I am not that person. No, teacher, I didn't cheat on that test," whatever it may be. So can we not blame him for, wanting to answer as a result of the interrogation type of questions that were asked?
Not quite, Your Honor. It would, as you say, be reasonable for someone who's accused of being an anarchist to defend themselves by saying, "No, I'm not an anarchist," which is what the defendant did. However, it would not be reasonable for a defendant to respond to those types of statements with an incriminating response regarding a crime. It was reasonable for him to say, "No, I'm not an anarchist," but it was not reasonable for him to immediately bring the conversation to Remi Montoya, since Officer Byrd never made any statements directly connecting the defendant to Remi Montoya.
Well, but shouldn't alarms gone off in Officer Byrd's head as soon as the defendant said, quote, "Do I need to call my lawyer?" I mean, obviously it's escalating at that point. He's feeling trapped, in custody, interrogated, whatever. And he asks that question. And shouldn't that send bells and whistles to Officer Byrd that, whoa, time out. Maybe I'm going a little too far and I should just shut up. No, he doesn't. He continues on. "No, that's not what I meant. I was speaking generally." He keeps just feeding the fire, waiting and trying to gather something from him.
So actually, Your Honor, in Officer Byrd's witness statement, he does say that he took note of the defendant becoming defensive, and so he tried to explain to the defendant that he did not suspect him of any crime and therefore was not trying to question him about any crime. So when you bring up statements like, "No, that's not what I meant. I was speaking generally. No one was accusing you of anything," these statements were not feeding the fire. These statements were intended to placate the defendant, and they would have placated any reasonable person in the defendant's position and made them realize that they were not being interrogated.
Well, don't you think he just could have simply placated him by saying, let's just wait till we get to the station. Everything's cool. Just relax. We'll be there in a couple minutes.
Your Honor, obviously, hypothetically, there are many avenues the officer could have taken. However, the avenue that he did take was making statements like, "No, I was speaking generally. I was not accusing you of anything." And these statements would be equally reasonably likely to placate any any person in the defendant's position.
All right, go ahead. Thank you.
Thank you. Moving on to my first point. The surrounding circumstances of the interaction between Officer Byrd and the defendant did not constitute a custodial setting. The distinguishable case of People versus Boyer offers a prime example of a true custodial interaction. In that case, the defendant was interrogated in a police station without any legal grounds for the restraint. Moreover, the officers consistently ignored the defendant's attempts to assert his right to silence and counsel. The court in that case held that because of those extremely coercive surrounding circumstances, that was a custodial interrogation.
Well, but the defendant in this case said, hey, do I need to get an attorney? I mean, he didn't beg several times like they did, the person in Boyer did, but at least he said, hey, do I need to call my lawyer? I mean, I don't think it's a quantitative thing. You have to ask so many times before, before something needs to happen, but they failed to honor his request or his inquiry, which, could be considered a request.
Actually, no, Your Honor. Inquiring as to whether or not you need a lawyer is not the same thing as asserting your right to one. Later on in the conversation, the defendant did assert his right to silence and counsel by stating, I think I'd like to speak to my lawyer now. That is asserting your right to silence and counsel. And when the defendant made that statement, Officer Beaart immediately obliged the request, stopped the conversation, and let the defendant wait until his counsel arrived.
Thank you. Go ahead.
And so in comparison to People versus Boyer, we do not see the same custodial factors present in today's case. At the time of the conversation, as previously mentioned, the defendant was not a suspect in any crime. She was merely a potential witness. She was not being detained in a police station. She was merely, she was sitting unrestrained in the back of a vehicle which she had voluntarily gotten into. And when the defendant decided to assert her right to silence and counsel, Officer Beaart obliged. These circumstances do not objectively amount to custody, and therefore, this was not a custodial interrogation. Second, the conversation between Officer Beaart and the defendant was not an interrogation. In the case of People versus Andreasen, officers engaged in conversations with the defendant regarding his life and interests. The court in that case held that such casual interactions are admissible, even if the defendant reveals incriminating information about themselves, as long as the questions themselves were not reasonably likely to elicit an incriminating response.
Well, what's casual about being accused of something that you are not? What's casual about somebody saying, you're a liar or you cheated on a test? That's not casual. That's in your face, confrontational, and calling you something and accusing you of something that you may be adamant about denying.
Yes, Your Honor. But the example that you give, while that may be not a casual conversation, that's not the same as what happened here today. Officer Beaart happened to recognize the defendant from his famous YouTube channel, and so he pursued a reasonable line of conversation, which was asking this famous YouTuber about her YouTube channel, where she expressed some very strong political beliefs that Officer Beaart decided to comment on.
Well, but Officer Beaart, though, originally was just trying to confirm that he was the same guy he's seen on it, okay? So he says, hey, aren't you that person? As soon as the defense says yes, then he's confirmed what his curiosity was. There's no more curiosity behind that. There's no reason to continue asking him any more questions because the initial inquiry was, I just want to know if you're that dude. Well, I know you're that dude, so end of story, right? I mean, why do we need to keep on interrogating him?
Not necessarily, Your Honor. If you were to meet a famous person, you wouldn't necessarily just be expected to stop at, hey, are you so-and-so? Yes, I am, and then let the conversation be. Since they were about to be in the car ride for quite a while, presumably, it was perfectly reasonable for the officer to continue a casual line of conversation regarding the defendant's occupation and her YouTube channel.
Thank you. Go ahead.
Thank you. So we see a similar fact pattern to People versus Andreasen in today's case. Officer Beaart's statements were casual and limited to the topic of the defendant's life and interests. He never directly accused the defendant of being connected to Mr. Montoya, nor did he ask inflammatory questions that would provoke such a response. And in fact, he even attempted to placate the defendant by clarifying that he was speaking generally, and that no one was accusing the defendant of anything. And so, Your Honor, because there was neither custody nor an interrogation in this case, the defense's motion to exclude the bracketed evidence should be denied. Thank you.
Thank you very much. Wonderful argument from both the parties, but I'll give obviously both parties an opportunity for rebuttal. Does the defense have a rebuttal at this time?
Yes, Your Honor.
Whenever you're ready, sir.
Your Honor, the prosecution first mentions custody. However, the issue here is that the prosecution harps on physical facts that indicate custody. However, today, the defense implores you to look at the mental aspects. In today's case, although there is no bar between the officer and the defendant is still in the backseat of the car and is still with the police authority. Even if Officer Beaart is in plain clothes, the defendant is fully aware that Officer Beaart is still an officer, evident by the fact that Officer Beaart had arrested someone living at the defendant's house at the time. At the end of the day, the standard is whether the defendant can leave at will. The defendant is in a moving vehicle going to the police station and is a witness to a crime of assault. It is unreasonable to assume that the defendant can leave the environment at any time they would choose. And thus, at the end of the day, even if several physical factors do point towards it being a casual environment, because the defendant cannot leave said environment, the defendant is still in custody.
1 minute.
Let's look to the second point, that of being interrogation. The prosecution argues that the Officer Beaart is focusing on casual conversation. Even if the first question is innocent and is casual, the moment the defendant said, "That is not me, I am not an anarchist," the officer should have ceased the questions. Rather, the officer continued asking questions. The prosecution argues that the officer said, "No one's accusing you of anything." However, it's important to note that happened at the end of the conversation after the defendant made the statements. It's important to note that up until those statements, the officer continued to accuse. Even with the in general line the prosecution mentions, the officer still accuses Croddy of creating content that can be taken out of context and can lead to anarchy, proving that Officer Beaart repeatedly created inflammatory statements that would try to get a rise from the defendant, something incriminating. For these reasons, we urge you to pass today's motion and make these statements inadmissible. Thank you.
Thank you very much, counsel. And does the prosecution wish to give a rebuttal at this time?
Yes, Your Honor. May I
Whenever you're
proceed?
ready.
Thank you. I have 2 points, Your Honor. First, the defense is claiming that merely by being in a police vehicle with a police presence, that is sufficient to constitute a custodial interrogation. However, this assertion is not supported by the case law. For instance, if we look at the case of People versus Lewis, the defendant was having a casual conversation with a police officer while sitting in the back of a police vehicle after being arrested as a suspect in a crime. And despite those circumstances, the court in that case held that that was insufficient to constitute a custodial interrogation.
Well, are you saying that the equivalent of, "Hey, is that you, Big Mike?" and the sergeant saying yes is equivalent to the long dialogue that we had between these two folks?
Yes, Your Honor. The legal standard is for whether something is a casual conversation versus an interrogation is merely whether the officer makes any statements that would be reasonably likely to elicit an incriminating response. So because the officer in this case, because Officer Beaart did not make any such statements, it's still on the same level as the conversation in People versus Lewis, in that they are both casual conversations.
Thank you. Anything further? Or is your time up? I'm sorry, I don't mean to interrupt you.
No, no problem. I do have some more points.
Go ahead.
So in comparison to People versus Lewis, the factors of today's case are arguably even less custodial because the defendant had voluntarily entered this vehicle. She was not being detained as a suspect in any crime. She was unrestrained. There were no handcuffs, no metal cage, no siren, the officer in plain clothes, an unmarked vehicle. All of these factors point to the undeniable conclusion that this was not custody. On to my second point, the defense continually claims that Officer Beaart was, quote unquote, trying to get a rise out of the defendant. However, as Your Honor rightfully pointed out, Officer Beaart made statements like, "No one was accusing you of anything," I was speaking generally.
30 seconds.
That's not what I meant. These statements do the exact opposite of what the defense is claiming that they would. These statements would be reasonably likely to placate and calm any person in the defendant's position. As a reminder to the court, the defense has the burden of proving both elements of a custodial interrogation, both custody and an interrogation. And the defense has failed to meet that burden. And so the motion to exclude the bracketed evidence should be denied. Thank you.
Thank you very much. I'd like to thank both parties for their presentation of this pretrial motion. I'm just going to take a second here to gather my thoughts and also allow our scorers to do the best they can to tabulate their scores. There being two wonderful presentations here. However, having read and considered the authority that was provided to this court supporting both sides in this dispute, or both sides in this case, and upon a review of the totality of the circumstances utilizing an objective standard, the court finds that the defendant was not in custody at the time that he was in the backseat of Officer Byrd's vehicle. The conversation between the parties, the two parties, was casual in nature and did not constitute a custodial interrogation designed to elicit incriminating evidence. It would appear that the statements made by the defendant regarding Remi were voluntary and that they were not in response to Officer Byrd's statement regarding the content of the defendant's YouTube media, but rather the defendant's own desire to switch the subject matter and directly make unsolicited statements about his interactions with Remi. Therefore, the motion is denied and the statements by the defendant are or will be admissible at this time. Again, thanks to both counsel for your presentations. We'll take a second now to switch over to our attorneys in regards to evidence and what they may want to do with that. So make sure we got everybody on board. I have the prosecution here. Do I have defense counsel in regards to discussion here on the physical evidence for inspection? Here we go. All right. Counsel, do either counsel, I'll start with the prosecution. Ma'am, do you have any physical evidence you'd like to present for inspection at this time?
Yes, Your Honor. The people asked to present exhibits A through C, located on pages 48 through 50 for inspection. Exhibit A is a photograph of Drew Marshak's briefcase. Exhibit B is the Twitter group chat from February 12th. And Exhibit C is the WhatsApp conversation between Croddy and Remi Montoya.
All right. And are there any objections by the defense at this time in presenting this evidence for inspection purposes?
No objections from the defense, Your Honor.
All right. Do either party wish to do anything in regards to this, these exhibits at this time, or are you choosing to wait until the presentation of your respective cases? People?
The prosecution will wait until we present the exhibits.
All right. Defense, same thing?
Yes, Your Honor.
All right. Thank you very much. The charges against the defendant in this matter as follows. The people of the state of California are charging the defendant, Croddy, on 2 counts. One, a violation of count 1, Penal Code Section 459-460, subsection A, burglary in the first degree, allegedly committed by Remi Montoya. That is under an aiding and abetting theory. The second count is a violation of Penal Code Section 32, an accessory after the fact to a felony committed by Remi Montoya. To these charges, the defendant has pled not guilty. He is presumed not guilty until the people can prove each and every element of both offenses beyond a reasonable doubt to this judge. With that, then, the court will entertain any opening statements. Is the prosecution ready to present its opening statement at this time?
Your Honor, before we begin, the people would like to address a few housekeeping matters.
Yes, certainly. Go ahead, ma'am.
Stipulations are located on pages 10 and 11, and the defendant has been identified per stipulation 11. And with that, the people are ready to proceed with opening statements.
So stipulated and agreed upon by defense counsel also?
Yes, Your Honor.
Yes, Your Honor.
All right there. Any other housekeeping matters from the prosecution before we proceed?
No, Your Honor.
Defense, any housekeeping matters before we proceed with the opening statement, ma'am?
No, Your Honor.
All right, then as soon as your prosecution is ready, you may present your opening statement, ma'am.
Yes, Your Honor. All strings lead to Lee Croddy. This case is about a puppet master pulling the strings of influence, psychological manipulation, and control to orchestrate the commission of a crime by one of her puppets. It's February 12th. The defendant, a social media influencer and conspiracy theorist, unleashed the name and address of a government official to Remi Montoya. This is string number 1. String number 2. The defendant then commanded Remi Montoya to demand answers from this government official, and if met with opposition, to, quote, take what is ours. String number 3. Lee Croddy then sent a direct, private message to Remi Montoya with specific instructions. Get the rest of the documents. Get into that house. On the very next day, Remi Montoya did just that. He broke into that government official's home and took those documents. Immediately after, Mr. Montoya went to his puppet master, the defendant, and reported what he had done. Upon hearing that her puppet had successfully broken into that government official's home and taken those documents, the defendant invited Mr. Montoya to her home to lay low. And that's why tonight, the defendant stands charged with first, aiding and abetting Remi Montoya's burglary, and second, with acting as an accessory after the fact. The people will prove that the defendant is guilty of these charges beyond a reasonable doubt. Remi Montoya will testify tonight about how the defendant pulled his strings to instigate and facilitate the burglary. Drew Marshak, the government official whose home was targeted by the defendant, will testify tonight that even as Remi Montoya was burglarizing her home, Mr. Montoya was still talking about, thinking about Lee Croddy. Next, the court will hear from Detective Max Bird, lead investigator in tonight's case, who will outline how his investigation led to the charges brought against Lee Croddy. Finally, Dr. Kai Chavez, psychology expert, will tell the court how the defendant created a toxic environment called groupthink that restricted Remi Montoya's ability to make individual decisions free from the defendant's influence. Remi Montoya had become the defendant's puppet. Your Honor, in this case, all strings lead to Lee Croddy. Thus, at the end of tonight's trial, my co-counsel, Mr. Burke, will ask the court to render the only verdict supported by the evidence, finding the defendant guilty on both counts. Thank you.
Thank you very much. Is the defense ready to present its opening statement at this time?
Yes, Your Honor.
Whenever you're ready, sir.
Thank you very much, Your Honor. Good evening, Your Honor. Tonight, you will hear a case about a real-life Pinocchio, a puppet that cut off its strings and acted on its own. During this trial, you will find that this puppet is Remi Montoya, and that the inconsistencies with the state's allegations become more apparent, just like how Pinocchio's nose rose with each lie. As such, at the end of this trial, you will find that Lee Croddy is innocent of all charges. Now let's talk about my client. Lee Croddy is a well-known social media idol, passionate about causes that affect the safety and well-being of others. Remi Montoya is an admirer and fan of Miss Croddy, and you will hear that Miss Croddy never asked Remi Montoya to break into Drew Marshak's house and never to steal her personal belongings. What you will hear is that on February 13th, Miss Croddy wanted to educate her followers about information she obtained. Miss Croddy discovered that the government is hiding information about a foreign entity that could potentially affect the safety of everyone in the country, and she posted a video on her YouTube channel called The Right Choice of News. She informed all of her followers that a government agent named Drew Marshak had access to documents concerning this issue. In a group chat with Miss Croddy and many other followers, including Remi Montoya, they agreed that they should demand information from Drew Marshak and should stand together in their pursuit for truth. And because Remi Montoya was in a location close to Drew Marshak, Miss Croddy asked Remi to advance their movement by going to Drew Marshak's house and demanding information. Miss Croddy will tell you that she never told Remi to break into the house or assault Drew Marshak. In fact, Remi Montoya admits that he was alone when he broke into Drew Marshak's house and stole her briefcase. After independently breaking into Marshak's house, Remi Montoya showed up at my client's meet and greet, obviously shaken, as you hear from Zuri O'Neill. My client was concerned for Remi Montoya in her current state, and my client tried to calm him down. You'll also hear from Lee Croddy's agent, Erin Sullivan, who will testify that my client cares deeply about her fans and often goes out of their way to help them. Sometimes she even lets them stay at her own house. And after the meet and greet, Remi was not in any condition to drive. And so my client drove Remi Montoya to her house, in which Remi stayed in Miss Croddy's guest house, not her secret bunker. The following morning, the police came to Miss Croddy's house and arrested Remi Montoya for burglary and assault. Miss Croddy was in utter shock because she does not condone breaking the law. At the end of the trial, you will find that, like Pinocchio, Remi Montoya simply cut off her strings and acted independently. And because Remi acted independently of Miss Croddy, at the end of the trial, we will ask you to find Lee Croddy innocent of all charges. Thank you.
Thank you very much, counsel. At this time, if I can invite both the prosecution and defense witnesses to turn on their cameras and unmute their microphones, I will take a moment to swear you all in. All right, let's see. We should have 8, I think, folks. 5, 6, 7, 8. All right, looks like I have 8 witnesses. Ladies and gentlemen, if you'll be kind enough to raise your hands, do you solemnly affirm that the testimony you will give in this trial will be faithfully and truthfully conform to the facts and the rules of the mock trial competition? If so, please respond by saying, I do.
I do.
I do.
All right. Thank you very much, ladies and gentlemen. And please turn off your cameras at this time and mute your microphones. Thank you. All right. At this time, if the prosecution is ready, they may call their first witness.
The people call Remi Montoya to the stand.
All right. And whenever your witness is ready, you may proceed.
Yes, Your Honor. Before I begin, I will be referencing Exhibits B and C during the examination.
All right. Thank you.
Good evening, Mr. Montoya. Could you please introduce yourself to the court?
My name is Remi Montoya. I'm a huge extraterrestrial enthusiast, and to pay the bills, I work retail at a toy store.
Why are you here tonight?
I'm here because I made a mistake.
A mistake? Could you please elaborate?
It was February 15th. I was outside the house of a government official named Drew Marshak. I broke in and I stole a briefcase. When I was leaving Miss Marshak's house, I ran into her. I was scared and I didn't know what to do, so I punched Miss Marshak and I ran away. Later, I pled guilty.
Objection, the witness is launching into a narrative.
Sustained. Ask your next question.
Yes, Your Honor. Mr. Montoya, did this lead to any criminal charges?
Yes, I pled guilty to burglary and assault.
Well, let's take a step back. How did you get yourself into the situation?
Well, it all started when I found Lee Croddy's YouTube channel. I became a huge fan. I followed all of her social media, I watched her videos, I went to her meet and greets. Lee even
Objection, the witness is once again launching into a narrative.
Sustained. Ask your next question.
Yes, Your Honor. Mr. Montoya, through what ways did you communicate with the defendant?
Lee added me to a group chat and he communicated with me through there.
And what was this group chat that you communicated through?
Sometimes Lee would send sneak peeks of videos, and in one of those videos about government secrets, he included Drew Marshak's address.
Well, let's take a look at that group chat located in Exhibit B. Do you recognize this exhibit?
Yes.
Is this a fair and accurate representation of that group chat that you were a part of?
It is.
What did the defendant say in this particular excerpt of the group chat that stood out to you?
On line 36, Lee said, "We have to make demands. March up to this Marshak person and demand answers. And if Marshak won't answer us, we will just take what is ours." Lee sent me a direct message after this.
Let's take a look at that direct message on Exhibit C. Is this a fair and accurate representation of that one-on-one conversation you had with the defendant?
Yes, it is.
What struck you as significant in this particular one-on-one chat?
Well, on line 13, Lee said, "Get the rest of the documents." And on line 31, Lee said, "You need to get into that house tomorrow." I didn't want to let Lee down, so I did what he told me to do. And I went to Miss Marshak's house on the 15th.
Your Honor, at this time, the people move to admit Exhibits B and C into evidence.
Any objection by defense counsel?
No objections, Your Honor.
Then Exhibit B and C will be admitted into evidence. Thank you.
Mr. Marshak, what did you do immediately following hitting, or excuse me, Mr. Montoya, what did you do immediately following hitting Ms. Marshak?
I panicked, but my first thought was to go to Lee. I just thought she would be able to help.
Where did you go to find the defendant?
I went to her meet and greet.
What did you do once you saw her?
I told her that I got all the documents that she wanted and that I got into a little altercation with Miss Marshak.
What did the defendant do upon hearing this?
Lee offered me a place to lay low. She assured me that no problem was too big to solve, and I believed her.
Thank you, Mr. Montoya. Your Honor, I have no further questions.
Thank you. Cross-examination?
Yes, Your Honor. Good evening, Mr. Montoya.
Good evening, Miss Lee.
After the meet and greet was planned, you said that you were excited because the plan started to seem more tangible to you, correct?
I mean, I had done what Lee wanted, so I was excited to please Lee.
Is that a yes?
Yes, it is a yes.
In fact, you said that you were ready to act,
Yes, I did say that.
but you admit yourself that the next steps were not yet specified by Lee. Isn't that right?
Well, Lee had privately messaged me and told me to get into Marshak's house.
Objection, Your Honor. The witness is being non-responsive. Move to strike the witness's response.
Overruled. You may ask your next question.
Mr. Montoya, did you admit that you were ready to act, although the next steps were not yet specified?
I was ready to carry out Lee's plan, yes.
Is that a yes? Thank you. On February 14th, Lee asked you to go to Marshak's house to get the documents, correct?
Yes, she told me to take the documents.
Isn't it true that Lee never gave you instructions to break into Marshak's house?
Well, just to clarify, are you asking me whether she explicitly said to break into Miss Marshak's house? Or
Yes,
whether...
explicitly, Mr. Montoya.
No, not explicitly, but she did imply it.
Objection, Your Honor. Move to strike everything after not explicitly as non-responsive.
Sustained. The yes shall remain. Everything thereafter shall be stricken and disregarded by the court.
She never told you to steal the documents, correct?
Again, you're asking whether she explicitly said the word steal.
Yes.
No, she did not use that exact word.
Yes or no? Did Lee ever tell you to commit an illegal act?
She told me to go to Marshak's house and take the documents.
Is that a no?
I interpreted it as I needed...
Mr. Montoya, I apologize for cutting you off, but I'm not asking for your interpretation. I'm asking you if Lee told you to commit an illegal act.
Not explicitly, no.
In fact, Lee explicitly told you, don't do anything I wouldn't do, correct?
Yes, she did say that.
When you went to Lee's meet and greet, you were very panicked, correct?
I was Very panicked, yes.
And as you said, you don't clearly remember what you said to Lee, yes?
No, I don't remember every single word I said.
You didn't explicitly tell Lee that you broke into Marshak's house, did you?
What I told Lee was that I got the documents that she wanted and that I got into a little altercation with Miss Marshak.
Did you tell Lee that you got those documents by breaking in?
No, we were in the middle of a meet and greet.
And you also didn't tell Lee that you stole Marshak's briefcase, isn't that right?
I told her that I got the briefcase. I didn't tell her that I stole specifically.
Later that night, when Lee was taking you to her house, Lee started to ask questions regarding the briefcase, correct?
Could you elaborate as to what questions he asked, please?
Of course. When Lee was taking you to her house, she asked if the briefcase was a prop, correct?
Yeah, she did ask me if it was a prop, but I later clarified that it was not a prop.
Your Honor, move to strike everything after yes is non-responsive.
Overruled. Let me ask you next question.
But when Miss Croddy asked you this question, you lost your temper at Lee, isn't that right?
Objection, Your Honor. Vague and ambiguous as to lost your temper.
You understand the question, witness?
I guess it could be construed that.
Well, no, just do you understand the question, yes or no?
Oh, yes, I understand that question.
All right, overruled. Go ahead. You can answer the question.
Yes, I did lose my temper because I had just committed a crime and I was super anxious and panicked.
And after you yelled at her, Lee stopped asking questions, yes?
Yes, she stopped asking questions after I clarified.
Did you ever hand Lee the briefcase that you stole?
I took the briefcase to Lee's house.
Your Honor, objection, the witness is being non-responsive. Move to strike the witness's response.
Sustained, the answer shall be stricken. Disregard by the court.
Mr. Montoya, did you ever hand Lee the briefcase that you stole?
No, I did not physically hand the briefcase to Lee.
You never allowed Lee to look at the contents of the briefcase, did you?
It's not that I didn't allow him to, but he didn't look at the contents of the briefcase.
So yes or no, did you ever explicitly tell Lee about the crimes that you committed?
I told Lee that I got into a little altercation with Miss Marshak.
Objection, Your Honor, the witness is being non-responsive. Move to strike the witness's response.
Overruled. Let me go ahead and finish with the answer, and then I'll entertain an objection if need be. Go ahead.
What I told Lee was that I got into Miss Marshak's house and I took the briefcase and that I got into an altercation with Miss Marshak. I didn't say the words that I committed a crime, no, to answer your question.
Your Honor, move to strike everything before no is non-responsive.
Overruled. You may ask your next question.
In fact, later that night, you pleaded with Lee to give you a place to lay low, correct?
I didn't necessarily plead, but he offered to let me stay at his place.
Once you were at Lee's house, did you plead with Lee to give you a place to lay low?
Objection, Your Honor. Vague and ambiguous is to plead.
Do you understand the word plead and more importantly, the question itself, sir?
Not particularly in this context.
All right. Does Sustained want to rephrase the question?
Your Honor, may I be heard?
Yes,
Your
sure.
Honor, the phrasing pleaded with Lee to give you a place to lay low is a quote directly from the witness's testimony in the packet. So I am simply asking if he agrees that he did plead with Lee to give him a place to lay low.
All right. Well, hold on. I'm just looking at those pages and let me just confirm that.
Yes,
yes, looking at line number 9 on page 28. All
Yes,
right.
Your Honor.
Objections overruled. Do you remember the question, sir?
No, could she?
All right. Why don't you repeat the question then, ma'am?
That night, did you plead with Lee to give you a place to lay low?
Yes, I did.
Thank you, Your Honor. No further questions.
All right. Any redirect by the people at this time?
No, Your Honor. May the witness be excused?
Yes, thank you very much. And the people may in turn then call their next witness. I'm being deliberately slow here so that our scorers can have an opportunity to gather their thoughts and not be rushed in their scoring. So with that, who would the prosecution like to call next?
The people call Drew Marshak.
All right, then. Whenever your witness is ready, you may inquire.
Your Honor, before I begin, the people inquire as to how much time is remaining for direct examinations and statements.
All right, if we can get that for this young lady.
The prosecution has 10 minutes and 7 seconds remaining for examinations, 5 minutes and 38 seconds remaining for statements. The defense has 4 minutes and 45 seconds remaining for their cross-examination and 5 minutes and 53 seconds remaining for their statement.
All right, thank you very much. Whenever you're ready, ma'am.
Your Honor, before I begin, I'll be referring to Exhibit A during my examination, located on page 48 for the court's reference.
Yes, the court has it. Go ahead.
Good evening, Ms. Marshak.
Good evening, Ms. Ponderangadoo.
Could you please introduce yourself to the court?
My name is Drew Marshak. I have been an investigator with the CADOJ's Bureau of Investigation for over 15 years. At work, I deal with confidential matters, but at home, there's no secrets between me and my cats.
Now, Ms. Marshak, do you remember the day of February 15th?
Of course I do. This kid, who I later learned was Remi Montoya, robbed and
Objection, Your Honor. The witness is launching into a narrative. The question called for a yes or no answer.
Not quite. Maybe the objection may be a little premature, but so go ahead.
Ms. Marshak, did you get a chance to finish your answer?
No. Remi Montoya robbed and physically assaulted me in my own home.
All right, ask your next question.
What happened?
I got home around 3 p.m. and my investigative instincts told me that something was wrong.
So what did you do next?
I walked into my home, I saw muddy footprints on my rug, and then I looked up and there was this kid, Remi Montoya, standing there. Before I could do anything, he punched me in my face.
And what happened after Mr. Montoya punched you in the face?
I looked up, I saw him standing above me, holding my government-issued briefcase.
Your Honor, the people ask for the court to turn its attention to Exhibit A. Now, Ms. Marshak, is this a fair and accurate photograph of that briefcase?
Yes, it is. It has my first initial, my last name, and my work insignia clearly placed on the front.
Your Honor, the people move to admit Exhibit A into evidence.
Any objection by the people?
No, Your
by
Honor.
defense, excuse me, by defense. No, none? Okay, thank you. Go ahead.
Now, Ms. Marshak, what happened next with Mr. Montoya?
I heard Mr. Montoya say, "At least I got the proof we needed." He mentioned something about trust, a revolution, and someone named Lee.
And what happened next?
Mr. Montoya bolted from my house, but not before saying, "I'm so sorry, I had to do it. This is for the people."
And what did you do next?
Right after that, I grabbed my phone and called the police.
Thank you, Ms. Marshak. Your Honor, I have no further questions at this time.
Thank you very much, counsel. Cross-examination whenever you're ready.
Yes, Your Honor. Before I proceed, I would ask the clerk for the cross-examination time remaining.
Whenever the clerk's ready, go ahead.
The defense has 4 minutes and 45 seconds remaining for their cross-examination, and the prosecution has 7 minutes and 57 seconds remaining for their direct examinations.
Thank you.
Thank you. Whenever you're ready, counsel.
Good evening, Ms. Marshak.
Good evening.
Allow me to draw your attention to the break-in. After Remi Montoya punched you, he appeared to be in a panic state, correct?
Yes, he did seem panicked after he punched me in the face.
Then he, after being in a panic state, he started to mutter, correct?
Yes, I heard him say something about Lee.
Well, specifically, you heard him mutter, "Oh no, what have I done? What am I doing?" Correct?
Yes, along with, "I had to do it. This is for the people."
Exactly. He said, "I'm so sorry. I didn't mean to. I had to do it. I had to do it. This is for the people." Correct?
Yes, I clearly remember that.
So Remi Montoya didn't say, "I'm so sorry. Lee Croddy told me to do this."
Objection, Your Honor. This question calls for an unfair extrapolation.
Your Honor.
I'm sorry. Go ahead. I'll hear from you, Ms. Ives.
Yes, Your Honor. An unfair extrapolation is a statement pulled out of nowhere that would alter the material facts of this case. This is not an unfair extrapolation because it is clearly outlined in the exhibit what Remi Montoya did and did not say. And I'm so sorry, Lee Croddy told me to do this is not one of these statements.
Anything
Your Honor,
further
if I
from the
may
people?
respond.
Yes, ma'am.
First, these statements are not included in any exhibits, and if in reference to Exhibit A, that is simply a photograph of Ms. Marshak's briefcase. Second, these statements would in fact be material facts, as any languished statements not presented in Ms. Marshak's witness statement would alter the facts of this case and go to show or disprove the elements of Calcrum 401 and 440.
Your Honor,
How would that, wait, hold on one second. How would this alter the material facts? Is this not just a reasonable inference or extrapolation that could be made from the evidence?
No, Your Honor, this is not a reasonable inference. Opposing counsel is trying to pull extraneous quotes that would help the defense in trying to deter away from elements of both 401 and 440.
All right, I'll give Ms. Ive the last word, then I got to make a ruling so y'all can finish up. Go ahead.
Your Honor, it may be an unfair extrapolation if we were trying to present these quotes as evidence, when in fact we are trying to do the opposite. We are asking that we are trying to say that Remi Montoya did not say, "I'm so sorry, Lee Croddy told me to do this." We are not trying to say that he did in fact say that. If we were to pretend that he said that statement when there is no evidence for that, that would be an unfair extrapolation. But as we do have an outline of the statements that Remi Montoya did say, and we know that this statement is not one of them, we therefore can say definitively that this was not an unfair extrapolation, that this was not a statement that was said at the altercation.
All right, the court's going to overrule the objection, find that the extrapolation was reasonable and therefore fair. Go ahead.
Would you like me to repeat my question, Ms. Marshak?
Please do.
Remi Montoya didn't say, "I'm so sorry, Lee Croddy told me to do this," correct?
Staying within the bounds of my witness statement, I cannot testify to that.
He did not say that, correct?
I can't testify to that. I don't know.
Well, in fact, the only time that you definitively heard Montoya mention Lee Croddy, he said Lee is not going to like this, correct?
Yes, that is what Remi said.
Thank you. Your Honor, I have no further questions.
Well, thank you very much. Any redirect by the people?
No, Your Honor, may this witness step down?
Yes, and thank you very much. And with that, then we will proceed in a moment here with the prosecution's third witness. And whenever the prosecution is ready, they may call that next witness.
The people call Deputy Max Beaart to the stand.
And whenever your witness is ready for inquiry, you may do so.
Your Honor, before we begin, the people inquire as to how much time is left for direct examinations and statements.
The prosecution has 7 minutes and 55 seconds remaining for their direct examinations and 5 minutes and 38 seconds remaining for their statements. The defense has 3 minutes and 15 seconds remaining for their cross-examination and 5 minutes and 53 seconds remaining for their statement.
Thank you. Whenever you're ready, you may proceed.
Yes, Your Honor. Good evening, Deputy Beaart.
Good evening.
Could you please introduce yourself to the court?
My name is Deputy Max Beaart, and I'm a 10-year veteran with the Beacon County Sheriff's Office.
Objection, Your Honor.
Wait, hold on. What's the objection?
It's unfair extrapolation and may it be heard.
What's unfair about the I think he said 10 years experience with the, was it Beacon Hills? What did you say? So it was 10 years experience with Beacon Hills?
10 years experience with the Beacon County Sheriff's Officer.
Okay, I'm sorry. I'll hear from you, Ms. Ives. Yes.
Specifically, my objection was to the fact that this witness's rank is deputy, when in fact it is simply stated as officer in the witness statement, and elevating his rank from officer to deputy would alter the material facts of the case by giving his testimony more weight.
Your Honor, if I may.
Well, I'll hear from the people. Go ahead.
It says on page 31, line 4, that Deputy Beaart is with the sheriff's station. A deputy is the lowest rank for officers under the sheriff, so this does not change Deputy Beaart's credibility or any material fact of the case.
the court will find that that is not an unfair extrapolation or anything that would affect a material fact or elevate him in any way inappropriately, and therefore the objection is overruled. You may proceed.
Deputy Byrd, how are you involved in this case?
I led the investigation into the burglary of Drew Marshak's house.
Let's talk about that investigation. How did it begin?
Well, I arrived 10:23 on scene at Miss Marshak's house and used the security camera footage outside of her house to get a physical description of the burglar.
What did you do with this security footage?
Well, based on the security footage, we released an APB and later received a potential address via that tip line.
What did you do upon receiving this address?
I responded code 3 to the address, which I now know is the home of Lee Croddy, and identified Remi Montoya when I arrived. I then announced myself as an officer and placed him under arrest.
Did Mr. Montoya say anything during his arrest?
Yes, ma'am, he did. He said, "We're starting a revolution here, my friend. Join us." He then nodded in the direction of the house where the defendant was at the time.
And so was anyone else present during your arrest of Mr. Montoya?
Lee Croddy came out after I placed Montoya in custody. I asked her a few standard questions, and she seemed very nervous and concerned for Montoya. She also said, "Oh God, what did Remi do? What did Remi take?"
Well, did you do anything else with Miss Croddy after this initial encounter?
Miss Croddy agreed to come down to the station with me to answer a couple more questions. So I drove her down there. She did say something that stood out to me, though. On our way down to the station, she said, "Sure, I told the kid to go down there and get those documents."
Well, what did you do at the station?
I conducted several interviews. I interviewed Mr. Montoya, Miss Croddy, and was later also able to interview Zuri O'Neill and Erin Sullivan.
Did you review any other materials from witnesses as part of your investigation?
I did. I looked over the witness statements that were on file at the department to gather some more information on the case.
Based on this information, what was your next step?
Well, based on everything I reviewed, I retrieved a warrant for Croddy's arrest.
What did you do upon receiving this warrant?
I returned to Miss Croddy's house and arrested her.
Thank you, Deputy Byrd. Your Honor, I have no further questions.
Thank you very much. Cross-examination when you're ready.
Yes, Your Honor. Good evening, Deputy Byrd.
Good evening.
Allow me to draw your attention to your investigation. You reviewed video footage from Miss Marshak's house, correct?
I did. I reviewed security camera footage from her house as well as getting statements from her.
And this video footage, to be clear, does not show Miss Croddy breaking into Miss Marshak's house, correct?
It does not.
Moreover, there's no video footage of Miss Croddy removing any items from Miss Marshak's house.
Not to my knowledge.
Next, allow me to draw your attention to Miss Montoya's witness statement. You collected this statement as a part of your investigation, correct?
I did. It was part of the many different elements I used in my conclusion.
And you believe that this statement clearly portrayed Lee Croddy as the prime instigator of the crime?
Objection, Your Honor. Calls for an improper lay witness opinion.
Yeah, Ms. Ives, would you like to be heard on that?
Yes, Your Honor. I'm simply first asking for what this witness's interpretation was in order to lay foundation for his further actions. And second, it is not an improper opinion, as this witness is a police officer. That means they are able to say what is or is not evidence as part of a crime. And further,
Go ahead.
Further, I would like to clarify that we are not using this statement as evidence, and we are not using his interpretation of the statement itself as evidence. Rather, the defense is trying to disprove the statement as a piece of evidence which this witness used in his investigation as he testified on direct.
So impeachment.
Oh, no, Your Honor. To clarify, we are trying to This witness testified on direct, among other witness statements, that he used Remi Montoya's witness statement as a part of his investigation. And in the line of questioning that the defense is going to proceed with, we are trying to disprove this as a valid piece of evidence.
All right, based on that offer of proof, the objection's overruled. Go ahead.
Yes, Your Honor.
I'm sorry, can you please restate your question?
Yes, please.
You believe this statement clearly portrayed Croddy as the prime instigator of the crime, correct?
I did. There were many pieces of evidence that led me to that conclusion, not just that witness statement.
Objection, Your Honor, the witness being non-responsive, move to strike everything after I did.
Overruled.
But Officer Byrd, you knew at the time of taking this statement that Remi Montoya had been arrested for burglary, correct?
2 minutes.
I did.
Specifically, he was arrested for burglary in the exact crime he was portraying Croddy as the prime instigator of.
I'm sorry, could you please restate the question?
Yes. The crime, you specifically knew that Remi Montoya was being arrested for burglary in the exact crime that in his witness statement, you gathered that he was portraying Lee Croddy as the prime instigator of.
Objection, Your Honor, vague and ambiguous. I believe the wording is confusing Deputy Byrd at the moment.
Well, let me ask him. Do you understand the question, sir?
No, I would like some additional clarification.
All right, one more time, if you don't mind, or a rephrasing, or
Okay.
Make it 2 questions, whatever y'all want to do.
I will break my question down to simplify it for the officer. First, you testify that you believe that this statement was portraying Lee Croddy as the prime instigator for the crime, correct?
I did. I used that as well as additional materials.
That crime being the one which Remi Montoya was arrested for.
Yes, Remi Montoya was arrested for that crime.
Yet you took the witness statement from Remi Montoya and accepted it as evidence that Lee Croddy was the instigator of the crime.
Well, we take all witness statements as evidence, and I reviewed the witness statements to gain some more information and insight into the case.
Thank you, Your Honor. I have no further questions.
Thank you very much. Redirect examination at this time.
No, Your Honor. May this witness be excused?
Yes, thank you very much. And
Thank you, Your Honor.
Thank you, counsel. And we'll transition then what appears to be now then the last prosecution witness. And whenever you're ready, you may call that witness to the stand.
Yes, Your Honor. The people call Dr. Kai Chavez.
All right.
And before I begin, I'll be referring to exhibits B and C during my examination.
All right. The court has access to those. And whenever your witness is ready, you may proceed, sir.
Thank you, Your Honor. Good evening, Dr. Chavez.
Good evening, Mr. Burke.
Could you please introduce yourself to the court?
Sure. My name is Dr. Kai Chavez, and I've extensively researched the concept of groupthink. I earned my bachelor's degree in psychology at the University of South Hudson, and then earned my MD with 3 years of residency. So I'm a real doctor. My residency specialized in various mental illnesses, and I've also served as an expert witness in nearly 150 cases prior to today's trial.
Dr. Chavez, what is groupthink?
Groupthink is a toxic environment where there is little room for individual decision-making. Participants in a groupthink environment will follow the orders of an idealized celebrity or leader.
Dr. Chavez, what characteristics help you identify instances of groupthink?
Groupthink is typically characterized by reoccurring rants that target the government or named officials, direct calls to action, and doxing, that is, the leaking of personal information online. These are all traits of an environment where individual decision-making is limited.
Now, Dr. Chavez, if I could direct your attention to exhibits B and C, where did you identify characteristics of groupthink in this case?
Lee Croddy posted rants on his various social media pages and group chats. For example, Lee Croddy targeted Drew Marshak on line 19 of Exhibit B, and I quote, The person who wrote these reports was stupid enough to put their name on it. Additionally, on line 7 of Exhibit B, Croddy says, "It's true. Aliens will be the next threat to our lives. Best stock up on supplies."
Dr. Chavez, what other characteristics did you identify?
Lee Croddy doxed Drew Marshak by releasing a video with her address to the group chat shown in Exhibit B.
Is that all, Dr. Chavez?
No, actually. Lee Croddy directly called his fan base to action in Exhibit B. Line 37 reads, "Demand answers," and line 38 reads, "Take what is ours." Lee Croddy also called Remi Montoya to action in Exhibit C. Line 13 reads, "Get the rest of the documents."
Dr. Chavez, are there any other characteristics of groupthink present in this case?
There are. Lee Croddy fits the archetype of an idealized personality and serves as the leader of the RCN fan base.
So, Dr. Chavez, based on your analysis, training, and extensive research, what can you conclude about groupthink in this case?
It is my expert opinion that the RCN fan base was a groupthink environment. As such, Remi Montoya acted in conformity with Lee Croddy's calls to action.
Thank you, Dr. Chavez. Your Honor, I have no further questions at this time.
Thank you very much, counsel. Defense counsel, whenever you're ready, Ms. Eisen.
Good evening, Dr. Chavez.
Good evening, ma'am.
Doctor, let's talk about groupthink. It's your opinion that personality disorders may predispose someone to groupthink, correct?
Objection, Your Honor. Unfair extrapolation. This question calls for material outside the bounds of Dr. Chavez's witness statement, if I may be heard.
Hold on one second. Let me just hear the question one more time, Ms. Eisen.
It's your opinion that personality disorders may predispose someone to groupthink?
All right, I'll hear from you, Mr. Burke, on that. And I have the witness statement, so if you're going to be referring to pages or lines, I can go directly there.
Yes, Your Honor. Particularly to the phrase predispose, the first page of Dr. Chavez's witness statement, line 16 and 17 state, those who participate in groupthink are arguably directly associated with traits of personality disorders. Nowhere in Dr. Chavez's witness statement or anywhere in the entire case packet does Dr. Chavez state that mental disorders predispose someone to groupthink. They're only arguably related.
Well, I think Ms. Ives used the term predisposed. Ms. Ives?
Yes, Your Honor. I specifically said may predispose, not specifically saying that it is 100% determining factor, simply that it is a factor that should be considered.
Your Honor,
yes, sir.
The word predispose is not in Dr. Chavez's witness statement or the case packet, Your Honor. Dr. Chavez may not testify to information beyond the scope of the case packet. What opposing counsel is asking Dr. Chavez to testify to would force him to create an unfair extrapolation, Your Honor.
Well, I think it goes down to, again, can one reasonably use the phrase directly associated and reasonably infer that one is one could be then also predisposed. The court is going to overrule the objection and find that extrapolation was fair. You may proceed.
Yes, Your Honor.
Dr. Chavez, would you like me to repeat my question?
30 seconds.
Yes, please.
It's your opinion that personality disorders may predispose someone to groupthink, yes?
First of all, I don't think personality disorders are a prerequisite to a groupthink environment.
I'm sorry, Dr. Chavez. I don't mean to cut you off, but you might have misunderstood my question. Personality disorders may predispose someone to groupthink, correct?
Could you rephrase the question?
Stop.
No, I'll allow, let's finish this up. I'll allow you to ask that question. Go ahead.
It's your opinion that personality disorders may predispose someone to groupthink, yes?
Once again, may I ask you to rephrase the question, please?
Well, I think, do you not understand the question, sir? It's just a yes or no question.
I'm having some trouble understanding the question as of right now.
Dr. Chavez, I'm sorry, though. Counsel did have a couple additional questions to ask of you in a cross-examination format. She's going to do that at this time. Ms. Ives, whenever you're ready, ma'am.
Dr. Chavez, I just have one question for you. Isn't it a fact that you have never met Remi Montoya?
I've never needed to meet him to come to my conclusions, ma'am.
Thank you, Your Honor. I have no further questions.
All right. Mr. Burke, anything about that is burning that you need to redirect?
No, Your Honor.
All right. Well, thank you very much, folks. I appreciate the banter and the discussion on these rules. Rules are very important, whether in any courtroom, and I'm glad that we could have that discussion. So now it appears that the people are choosing to rest. Is that correct?
Yes, Your Honor. The people rest at this time.
People having rested, then we will move to the defense case, and at this time, the defense may call their first witness.
Yes, Your Honor. The defense calls Zuri O'Neill to the stand.
And whenever your witness is ready, you may inquire.
Thank you very much, Your Honor. Good evening, Miss O'Neill.
Hi.
Please tell us, how old are you?
Now I'm 18.
And do you work?
Yes.
What is your occupation?
Well, you see, I'm very interested in research. I work as an intern for Atlantis Nightly. I'm sure you've heard of it.
So, excuse me, Mr. Joe. Miss O'Neill, do you have an opportunity to get a little closer to the microphone? If I'm having a little difficulty, I'm sure our scores might also. So I'm sorry to interrupt. Go ahead, sir.
Thank you, Your Honor. Are you familiar with a person named Lee Croddy?
Yes.
How do you know Miss Croddy?
Well, through my line of work as well as social media. You know, social media is actually how I got into a group chat with Lee.
Regarding these group chats that you mentioned, were there any other people present in these chats?
Yes, a few.
Who were these people?
Lee, Remi, a few other people, and myself.
Do you remember being in this particular group chat on February 12, 2020?
Yes. You know, that convo, I'll never forget.
Ma'am, by a convo, do you mean a conversation on social media?
Yeah.
Please tell us what you were discussing that day.
That day, Lee scored big info. He got some big info.
Please tell us what you mean by big info.
Like big information. You know, he scored big. He got information about the government, how they're hiding information about the existence of aliens.
How did you find out that Lee had this information?
Well, she sent us a sneak peek.
Do you know who in the government has this information?
Yes.
Who is this government official?
Drew Marshak.
How do you know who this government official is?
Well, I saw a glimpse of his name and his address in the sneak peek.
Regarding this address that you saw in the sneak peek, after you watched it, did you have any conversation about this address with Miss Croddy?
No.
And at any time after you watched the sneak peek, did Miss Croddy tell you to go to the address in the video?
No, she would never say that.
Did Miss Croddy ever tell you to do anything with the address?
No, she would never say that.
Objection, Your Honor. Lack of personal knowledge as to she would never say that. This witness simply does not have the personal knowledge to make a claim like that.
Sir, Drew?
Yes, Your Honor. Since Miss O'Neill has had experience with Miss Croddy in the group chats for well over a year, she would probably know what kind of content and what things that Miss Croddy would say to her.
I'm sorry, I'm going to refer to you as counsel because you have a beautiful last name, and if I try to pronounce it, I'll really mess it up. So
yes, Your Honor.
Counsel, and for both of you. So anyway, people, what are your thoughts?
Yes, Your Honor. While Miss O'Neill does have the personal knowledge with this group chat, she does not have the personal knowledge to be testifying about what's going on inside Miss Croddy's head. The claims she's making are far outside the bounds of her personal knowledge.
I'll give you the last word, defense counsel.
Yes, Your Honor. This is simply the opinion that Miss O'Neill is putting out. Obviously, she doesn't know what is going on in Miss Croddy's head, as no one would. So she is simply putting out what she thinks Miss Croddy said.
So it's opinion character evidence?
Yes, Your Honor.
All right, people, last word, and then I got a rule so we can move on.
Nothing further from the people.
All right, objections overruled. Go ahead.
Would you like me to repeat my question, Miss O'Neill?
Yes, please.
Did Miss Croddy ever tell you to do anything with the address?
No, she would never say that because she cares about us and she cares for our safety.
Objection, Your Honor. Lack of personal knowledge and improper character evidence to she would never do that. She cares about us.
Sustain.
Motion to strike that testimony.
The court will strike the latter part of it. I think the first word or two that shall remain, everything, and I can't remember the exact words, but there was she answered it, I think, a yes or no or something of that nature. And then that shall remain, everything thereafter shall be stricken and disregarded by the court.
Yes, Your Honor.
Your Honor, may I proceed?
Yes, sir, whenever you're ready.
Thank you. And finally, Ms. O'Neill, on the date in question, during this group chat, did anyone in the group chat talk about this address?
No, we never talked about that.
Thank you, Your Honor. I have no further questions.
Thank you very much, counsel. Cross-examination?
Yes, Your Honor. Good evening, Ms. O'Neill.
Good evening.
You mentioned some group chats on direct examination. I'm going to ask you a few questions about that. When you were first chosen to engage in this non-public group chat, you were initially uncomfortable by communicating per this media, correct?
Well, I trusted Lee's judgment.
Is that a yes to my question?
Yeah, I always want to stay well informed.
But because of your trust in the defendant, you began to engage in this group chat quite a bit more, wouldn't you say?
Well, she invited me to a group chat, so.
Is that a yes?
Yes.
And you communicated with Miss Croddy 2 or 3 times per week, wouldn't you say?
Yeah, I guess.
But Lee Croddy never privately messaged you, correct?
Objection, Your Honor, relevance.
Overruled at this point. Go ahead.
But Lee Croddy never privately messaged you, correct?
Correct.
Now, you would say that Miss Croddy's words mean what they say, correct?
That is what I love about Lee and RCN.
And you would say that there's no subtext or hidden meaning?
Again, that is what I love about Lee and RCN.
That's a yes to my question.
Yeah.
Now, within the defendant's publicly released video on February 13th, no name or address of any government official was clearly visible, correct?
Once again, objection, Your Honor, relevance.
Overruled at this point.
Ms. O'Neill, please answer the question.
May you please ask the question again?
Of course. Within the defendant's publicly released video on February 13th, no name or address of any government official was visible, correct?
Correct.
But within the sneak peek that the defendant sent your group chat, the name and address of a government official was clearly visible, correct?
I saw a glimpse of it.
Is that a yes to my question?
I saw a glimpse. I guess I saw it, so yeah.
Objection, Your Honor, the witness is being non-responsive. Permission to strike everything before the yes.
Overruled.
Thank you, Ms. O'Neill. Your Honor, I have no further questions at this time.
Thank you very much, counsel. Redirect at this time. Defense counsel.
Yes, Your Honor. Oh, my apologies. Yes, Your Honor.
Yeah, whenever you're ready, sir.
Thank you. Ms. O'Neill, I have one question for you on this redirect examination. Has Ms. Croddy ever told you to do anything illegal in the past?
No.
Thank you, Your Honor. I have no further questions.
All right, thank you very much. May this witness be excused.
Yes, Your Honor.
All right, thank you very much for your testimony. And whenever defense counsel is ready, they may inquire or call, their next witness.
Thank you, Your Honor. The defense calls Erin Sullivan to the stand.
All right. Mr. Sullivan, just give us a moment here. And counsel, whenever you're ready, you may inquire of Mr. Sullivan.
Your Honor, before I begin, may I inquire as to how much time I have remaining?
Sure, Madam Clerk, or sir, I'm sorry, Mr. Chen.
Your Honor, the defense has 11 minutes and 50 seconds for direct examination, and the prosecution is 8 minutes and 18 seconds for cross-examination.
Thank you very much, sir. Whenever you're ready, counsel.
Thank you, Your Honor. Good evening, Mr. Sullivan.
Good evening.
Please tell us, what's your occupation?
Well, I've worked as Lee Croddy's agent for about the past 3 years, and together we've hit so many milestones. I'm so proud of all of our accomplishments.
Mr. Calloway, I'm sorry, can you just get the volume up a little bit more, sir, please?
Yes, Your Honor, I apologize.
Thank you very much. Ask your next question, defense counsel. Sorry.
Thank you, Your Honor. What do you do as Miss Croddy's agent?
Oh, well, I make sure that her brand is taken care of. I take care of her social media. I network for her. And I also take care of the legal and business side of her brand as well.
Please tell us, what do you mean by brand?
Oh, everything about her, how she's represented. But since we lean so heavily on social media, I am specifically referring to her YouTube channel called The Right Choice of News, or the RCN for short.
You also mentioned that you take care of the legal sides of Lee's brand. Can you give us an example of this?
Sure. So while I am not personally an attorney, we have a panel of attorneys who we work with to ensure that we're on a sound legal standing. So one example is we advise her to put disturbance warnings on the beginning of videos so that the viewers didn't get unnecessarily triggered.
And if I recall correctly, Mr. Sullivan, you also mentioned that you manage Ms. Croddy's social media. Do you know if she has interacted with a person named Remi Montoya on these platforms?
Well, thanks to my idea of engaging social media celebrities with their fans by way of group chats, I do know that they're acquainted, yes.
Based on their interactions in said group chat, how would you describe their relationship?
Well, I believe the two had a typical idol-fan relationship where Remi obviously respects and looks up to Lee, who is the idol.
Have you ever seen the two of them interact in person?
Yes, I saw them interact at Lee's meet and greet.
And regarding this meet and greet, after the event was over, were you still present at the site?
Yes, I was.
Was Remi Montoya also present at the site when the event was over?
Yes.
And did you see Miss Croddy there as well once the event was over?
She was there as well, yes.
Were the two, Remi Montoya and Miss Croddy, interacting when the event had finished?
Yes, they were talking to each other.
Do you know what they were talking about?
Yeah, afterwards, Lee came up to me and told me that Remi was going to be staying the night at her house.
Objection, Your Honor, lack of personal knowledge. While Mr. Sullivan does have the knowledge to what Ms. Croddy may have told him about the conversation, he cannot testify to the conversation as a whole.
Defense counsel?
Your Honor, I can rephrase.
All right, then sustain. Why don't you rephrase the question?
Mr. Sullivan, after Ms. Croddy and Remi Montoya finished whatever conversation they were having, did Ms. Croddy ever speak to you?
Yes, she came up to me and told me Remi would be staying the night at her house.
Do you know why Ms. Croddy was going to take Remi home?
Well, Lee is very caring towards all of her fans. That's why I personally enjoy working with her so much. Even though I specifically warned her not to get too close with any of her fans, she does this kind of thing for them when they're in distress.
Objection, Your Honor, lack of personal knowledge again as to exactly why Lee Croddy wanted to take Remi Montoya home that day.
Overruled.
Your Honor, may I proceed?
Yes, sir.
Thank you. Finally, Mr. Sullivan, is this something that Ms. Croddy would normally do, helping out fans in need?
Oh, yes.
Thank you, Your Honor. I have no further questions.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Good evening, Mr. Sullivan.
Good evening.
Regarding February 15th, you were at Lee Croddy's meet and greet, correct?
That's correct.
And you noted an interaction between Ms. Croddy and Mr. Montoya?
They seem to be talking to each other in the cafe, yes.
And you noted that this interaction was unlike Ms. Croddy's interactions with any other fan, correct?
At this meet and greet, yes.
So that's a yes to my question.
At this meet and greet, yes.
Objection, Your Honor. This witness is being non-responsive. This is clearly a yes or no answer. Yes or no.
No, overruled. You can ask a follow-up question if need be.
Yes, Your Honor. And you assumed that Lee Croddy knew this person quite well, wouldn't you say?
Objection, Your Honor, calls for speculation.
Overruled at this point. Go ahead.
Mr. Sullivan, you assumed that Lee Croddy knew this person quite well, correct?
Well, as they were talking to each other, I assumed they knew each other, yes.
And Mr. Croddy called Remi a friend?
That's correct.
Now, Mr. Sullivan, you know about a WhatsApp conversation between Mr. Croddy, Ms. Croddy, and Mr. Montoya, correct?
Yes, I do.
In it, Ms. Croddy wanted to discuss getting some documents from a government investigator, didn't she?
Yes, that's a fair assessment.
Did she or did she not say that?
No, she did.
Thank you, Mr. Sullivan. Your Honor, I have no further questions.
Thank you very much. Any further redirect, counsel?
Yes, Your Honor.
Whenever you're ready, sir.
Thank you, Your Honor. Mr. Sullivan, in your experience as Lee Croddy's agent, has she ever advocated for illegal activities in her videos in the past?
Oh, goodness, no. I make sure of it.
Thank you, Your Honor. I have no further questions.
All right. Thank you very much. May this witness be excused, counsel?
Yes, Your Honor. Thank you.
All right. Thank you very much, sir, for your testimony. At this time, the defense may call their next witness to the stand whenever you're ready, sir.
Your Honor, the defense would like to call Dr. Jes Beaart to the stand.
Excuse me, ma'am. I apologize there. I got so many different genders and faces, and you kids are having a hard enough time remembering them all. My apologies if I do that again. I'll do my best. I'm sorry. You're calling whom now, Miss Ives?
I'm calling Dr. Jes Beaart.
All right, then. Whenever your witness is ready, you may proceed, ma'am.
Good evening, Dr. Beaart.
Good evening, Miss Ives.
What is your occupation?
Well, I work as a professor of sociology at Beechwood University.
What education led you to becoming a sociologist?
I have a PhD in sociology from Peterson University, and my doctorate mainly focuses on how social media can influence social movements and activism, particularly in young adults.
How are you involved in today's case?
I was asked to review communications between Lee Croddy and Remi Montoya in order to determine whether Lee could be considered purely a catalyst for a movement, or rather a leader who directed all of the actions within said movement.
What do you mean by movement?
Well, when using the word movement in social media, what we're really talking about most of the time is social media activism, and activists on social media can be thought of in two basic ways. The first one being a catalyst for a movement.
Objection, Your Honor. The witness is launched into a narrative.
Sustained. Ask your next question.
You mentioned social media activism. How is this usually carried out?
Activists on social media can be typically separated into two basic categories. One, they can act as a catalyst for a movement, meaning that they seek to inspire others rather than direct independent action. Or secondly, they can be someone who actually organizes, leads protests within their movement.
You also mentioned that you reviewed Lee and Remi's communications. Please describe what you mean by that.
Well, I reviewed private messages between Lee Croddy and Remi Montoya, as well as some group messaging on some social media platforms.
What opinions did you derive from your investigation of this evidence?
Objection, Your Honor. Lack of foundation as to Dr. Beaart arriving to conclusions based on the evidence. No actual foundation has been laid as to which specific facts led to her conclusions, Your Honor.
Size?
Your Honor, proper foundation has been laid as the witness has testified that she was in fact retained in order to draw opinions from the evidence that I had mentioned.
Mr. Burke, anything further, sir?
Yes, Your Honor. Dr. Beaart simply reviewing and having access to materials is not sufficient foundation for her to come to conclusions about those materials, as in what specific statements led to her conclusion and how those statements led to her conclusion, Your Honor.
All right. Objection sustained. Ms. Ives, why don't you lay a little foundation as to what she looked at in order to arrive at her opinion?
The communications that you just mentioned, did they help you in any way?
Objection, Your Honor. Vague and ambiguous as to help you in any way.
Do you understand the question, Dr. Beaart?
Yes, I do.
All right. Overall, go ahead.
They were very influential in how I drew my conclusions about this case.
And what conclusions did you draw?
Objection, Your Honor. There is still a lack of foundation for those conclusions. Again,
Mr. Burke, what's missing in your mind?
What specific statements led to Dr. Beaart's conclusion and how those statements led to Dr. Beaart's conclusion.
Overall, you can jump all into that in cross if you want to.
Yes,
go ahead.
sir.
Would you like me to repeat my question, Dr. Beaart?
Yes, please.
Please tell us what those conclusions were.
First, I could conclude that Lee clearly seems like the type of political influencer who was a catalyst for their movement and did so by purely providing the idea of a political goal. And secondly, I could determine that Remi is the type of activist who can easily act independently of a political influencer that they idolize, in this case being Lee Croddy.
How did you derive your first opinion?
Well, based on my review of the material, Lee clearly seems to be the type of person who seeks to inspire others rather than direct them.
Objection, Your Honor. Improper expert opinion. If I may direct the court's attention to page 69 of the case packet, Your Honor.
Hold on, let me get to that page. 69. Yes, sir. Looking at 69, and what area would you like to draw to the court's attention, sir?
Lines 12 through 14.
Looking at them, have them highlighted and have them underlined with red. So go ahead.
Fantastic, Your Honor. Dr. Beaart just testified to the intent of Lee Croddy and how he hoped his social media communications to be perceived. Your Honor, an expert witness is not allowed to testify to the mental state of a defendant in a criminal case. And Your Honor, intent is one of the 4 elements that must be proven to show that Lee Croddy committed aiding and abetting the first-degree burglary, Your Honor. Dr. Beaart's conclusion is an improper expert witness opinion.
Besides, what are your thoughts?
Your Honor, the witness simply said that she believes that Lee appears to be the type of political influencer who is a catalyst for a movement. And this is not an improper expert opinion, as is previously stated, that Dr. Beaart is a professor of sociology who specifically focuses on social media movements and catalysts of movements. And she's not trying to read Lee Croddy's mind per se. She's simply trying to characterize the movement which Lee Croddy was a part of, which is her expert opinion.
Your Honor,
yes, go ahead, Mr. Burke.
I'm not objecting to Dr. Beaart's lack of credentials, Your Honor. I'm objecting specifically to the statement about Dr. Beaart telling the court that Lee Croddy sought. She used the word seeks during her testimony, Your Honor. And seeks leads directly to intent, which is one of the elements of the criminal charges in tonight's case, Your Honor. According to the mock trial rules of evidence, Dr. Beaart's conclusions are an improper expert witness opinion.
All right, Ms. Ives. The court is going to sustain the objection only because, and again, we're getting into words, but words are very important, especially on this issue. As you articulated in your argument, what you felt she said was different than, I think, what came out. So if you want to rephrase the question, that's fine. I'm not precluding you from asking her opinion. But again, words are important, and I would agree with Mr. Burke that that word could fall within that umbrella of an ultimate opinion, which is not one that she can give, but is one that I ultimately will make. So if you'd like to rephrase it so that there's not that possibility of interpretation, by all means, go ahead.
Your Honor, motion to strike the relevant testimony.
The answer shall be stricken and described by this court, but I'll allow Ms. Ives to rephrase the question if you'd like, ma'am.
Dr. Beaart, you previously testified that you would characterize Lee as a catalyst in the movement. Why do you say that?
All of her videos seem to surround the idea of getting information out into the public and didn't really call to any direct specific action.
Moving on to your second opinion, that you believe Remi is the type of activist who is capable of acting independently. What allowed you to draw that conclusion?
Remi's participation on social media, like his posts on Twitter, suggests that he is a stan or a hardcore fan who ardently idolize the object of their affection. And young stans like Remi can typically act independently of political influencers that they idolize. And in some cases—
Objection, Your Honor, the witness has launched into a narrative.
I think she's about to wrap up, so overruled. Go ahead.
And I was saying, in some cases, they can actually completely surprise their idols by their actions.
All right, thank you. Go ahead and ask your next question.
Turning your attention to Exhibit C on page 48, do you recognize this exhibit?
Yes, I do.
Was this exhibit relevant to your opinions in any way?
Yes.
How so?
On specifically lines 35 through 36, Lee tells Remi to, quote, not do anything I wouldn't do, which again seems to clarify that her ideas of what should occur don't specifically in line with her fans directly.
Objection, Your Honor. Again.
Hold on. Go ahead, Mr. Burke. What's the objection, the basis in your argument?
Improper expert opinion. Again, Dr. Beaart just testified as to Lee Croddy's ideas about how he wanted those messages to be perceived. Again, Dr. Beaart cannot testify to Lee Croddy's mental state because this is a criminal trial and Lee Croddy is the defendant.
Besides, your thoughts?
Yes, Your Honor. This witness simply testified to lines 35 through 36 of Exhibit C, specifically the lines not to do anything that I wouldn't do. And she specifically wanted to testify how that line contributed to her end opinion. And in doing so, she does not mean to testify what Lee's intent was. Specifically, she says that this statement appears to say that she doesn't want Remi to do anything that's outside of the law. But this is not something that is an improper expert opinion, as it is something that can be reasonably inferred from this statement.
Mr. Burke, appears seems to be the word appears and intent seems to be the two words we're fighting over here. What are your thoughts?
Yes, Your Honor. Opposing counsel just stated that Dr. Beaart testified about Lee Croddy's wants, and Your Honor, want is under the category of intent, and intent is one of the elements of tonight's charges, according to the mock trial rules of evidence.
All right.
Testimony, proper expert opinion.
Mr. Stain, rephrase the question, Ms. Ives, just so we can clear up the one word issue I think that we have here.
Motion to strike the relevant
The
testimony.
answer shall be stricken, disregarded by the court. Go ahead and rephrase your question or clarify it if you can.
Your Honor, please just point us, oh, sorry, not Your Honor. Dr. Beaart, please just point us to the specific lines that you found relevant.
Again,
Referring to Exhibit C, go ahead.
Yes, on Exhibit C.
35 to 36 on Exhibit C, which say, don't do anything I wouldn't do.
Finally, Doctor, based on your knowledge, experience, skills, and training, did Remi, in your opinion, act independently of Lee?
Well, within a reasonable degree of professional certainty, it seems clear Remi would have easily been able to separate his adoration from his idol over the reality of his actions, and therefore should have been able to act completely independently.
Thank you, Your Honor. I have no further questions.
Thank you very much. Mr. Burke, cross-examination, sir.
Yes, Your Honor. May I proceed?
Whenever you're ready, sir.
Thank you. Good evening, Dr. Beaart. According to your research, Stens idolize celebrities, correct?
Yes, that's right.
And Remi Montoya idolized Lee Croddy, didn't he?
Yes, he did.
And Dr. Beaart, you're aware that Dr. Chavez categorizes an idolized celebrity as one of the characteristics of groupthink, don't you?
That is what he says.
Thank you. Dr. Beaart, now if I could direct your attention to Exhibit C, please. Lines 13 and 14 of Exhibit C read, get the rest of the documents, don't they?
Yes, they do.
And Remi Montoya obtained documents from Drew Marshak's house, correct?
Illegally, yes.
And Dr. Beaart, lines 31 and 32 of Exhibit C read, you need to get into that house tomorrow, don't they?
Yes, they do.
And Remi Montoya entered Drew Marshak's residence, didn't he?
Broke in illegally, yes.
But Remi Montoya did enter Drew Marshak's residence.
Objection, Your Honor. Asked and answered.
Sustained. Ask your next question.
Yes, Your Honor. Dr. Beaart, I'd like to talk to you about your credentials for a moment. You have degrees in marketing and sociology, don't you?
Yes, I do.
Now, on direct examination, you talked quite a bit about the mental states of Lee Croddy and Remi Montoya. You don't happen to have any graduate degrees in psychology or psychiatry, do you?
Objection, Your Honor. Relevance and may it be heard.
Sure, go ahead.
The statements pertaining to Lee Croddy's state of mind were very ardently stricken by the prosecution. Therefore, this question does not actually pertain to anything that was asked on direct and seems to only try to discredit this witness's credentials, which is not fair given that they were very clearly presented, and the fact that she is not a psychologist is not relevant to the case since her testimony had to do with sociology.
Mr. Burke, I'll give you the final word. Go ahead, sir.
Yes, Your Honor. 2 points. First, Dr. Beaart did testify to the mental state of Remi Montoya on direct examination. And second, Your Honor, Dr. Beaart's credentials are incredibly relevant to her conclusions and how much credence they should be given, especially in comparison with Dr. Chavez's credentials, specifically his bachelor's degree in psychology and MD, Your Honor.
All right. Why don't we then just keep the question as to her degree or lack of degrees? rather than prefacing it with any connection with any of her opinions. And then the court will weigh that evidence, all the evidence, and determine what the facts are and determine credibility of all witnesses. Go ahead.
Yes, Your Honor. Dr. Beaart, you don't have any graduate degrees in psychology or psychiatry, do you?
No,
You don't have any bachelor's degrees in those subjects, do you?
I do not.
You don't have any professional medical experience like an MD, do you?
No,
So, Dr. Beaart, you must have spoken to Lee Croddy to come to your conclusions then.
no, I did not. It wasn't necessary.
Well, you must have at least spoken to Remi Montoya.
Objection, Your Honor. Argumentative.
Overruled. Go ahead.
Dr. Beaart, you didn't speak to Remi Montoya to come to your conclusion, did you?
No, I did not.
Thank you, Dr. Beaart. Your Honor, no further questions.
Thank you, Ms. Ives. Any redirect, ma'am?
Yes, Your Honor. Dr. Beaart, do you believe that you have the necessary credentials to testify as to this case?
Yes, that's
Objection,
absolutely.
Your Honor. Relevance as to Dr. Beaart's belief about her credentials.
Overruled. Go ahead.
Could you repeat the question, please?
Well, no, you answered it, I think, right, Ms. Ives? Did she answer to your satisfaction? Okay,
I believe she was interrupted by prosecution.
Well,
so
tell you
I
what,
could-
Ms. Ives, why don't you ask the question over again, and then we'll allow her to finish it. I thought she had finished, so go ahead.
Okay. Do you believe you're able to testify on this case?
Yes, absolutely. My extensive education backs my conclusions.
Thank you, Your Honor. I have no further questions.
All right, may this witness be excused then.
Yes, Your Honor.
All right, well, thank you very much for your testimony. At this time, the defense may call their final witness for this evening. And whenever you're ready, please feel free to call that witness.
Your Honor, the state would like to call Lee Croddy to the stand.
All right. Hello, Ms. Croddy, and whenever counsel is ready, you may inquire of your witness.
Good evening. Please introduce yourself to the court.
Good evening. My name is Lee Croddy, and I'm the host of the YouTube channel, The Right Choice of News, the RCN.
Do you know Remi Montoya?
Yes, I do.
Please tell us more about your relationship with Remi.
I don't really know him well, but based on our interactions in a group chat, I believe he has the same passion for exposing the truth.
You mentioned that you have a group chat with Remi. Please tell us more about this group chat.
Yes, the chat includes Remi, Zuri, and a few other people. They're all my most loyal fans, and I send them sneak peeks of videos.
Do you recall the conversation you had with this group chat on February 12th?
Yes, I do.
What do you recall about that conversation?
On February 12th, I sent the chat a sneak peek on how the government is hiding aliens from the public. In the sneak peek, I accidentally forgot to censor the name and address of Drew Marshak, a government agent.
What did you do after making this mistake?
The next day, I posted the video to YouTube like normal, but this time I made sure to censor Marshak's private information.
What happened the day after you posted the video?
I had a meet and greet planned, but I thought it would be a great idea to bring some evidence down and share it with the group.
How did you plan to get this evidence?
I was going to go myself, but I was busy, so I asked Remi.
Objection, Your Honor. Unfair extrapolation as to Ms. Croddy was going to go get the documents herself.
Yes, Ms. Lee, would you like to point to me something in her factual statement or some type of reasonable inference that would lead us to that statement?
Yes, Your Honor. An unfair extrapolation is one that would significantly impact the outcome of the case. And this is not an unfair extrapolation, as whether or not Ms. Croddy was busy or was not busy, the fact that Remi Montoya was the person that went to Marshak's house to get the documents does not change. And therefore, this would not change the outcome of the case significantly.
Therefore, it's not relevant. It should be stricken then, right?
Your Honor, although it is relevant as it goes to the fact that Ms. Montoya would have done so herself, but because she wasn't able to do so, she had to ask Remi. And this fact that she was too busy and could not do so herself is not an unreasonable extrapolation, as it is
but
quite...
what is it relevant for, though?
Your Honor, it is relevant because it shows that Ms. Croddy was busy and was not able to go herself. And that is the reason why she had to ask Ms. Montoya to do a favor, Mr. Montoya to do a favor for her.
People?
Your Honor, The fact that Ms. Croddy is saying that she would have gone herself, it changes her intent and her motive as to why she would ask Ms. Montoya to go get the documents. And so that does, intent is an element of proving the charges, and so that does change the material facts of the case.
We'll give you the last word, Ms. Lee.
Your Honor, if I may direct the court's attention to Exhibit C, lines, I believe, 13 to 14, Ms. Montoya does in fact state, "I won't be in the area tomorrow, otherwise I do it myself." And therefore, this is not an extrapolation. It is something directly in the case packet.
All right, people, I could give you the last word on that because she's brought up a point there. So what's your word on that? And then I'll rule.
Your Honor, just because it says, "I won't be in the area tomorrow, otherwise I do it myself," doesn't necessarily show that just because of that, she decided to ask specifically Remi Montoya. And she did specify, Ms. Croddy specified that she decided to ask Ms. Montoya specifically for this reason, but that reason is not seen in this statement.
All right. Well, I think the extrapolation was fair, and it's a reasonable inference in light of what's contained in Exhibit C. Therefore, the objection will be overruled. Go ahead.
Ms. Croddy, when you asked Remi Montoya for this favor, did you tell Remi to break into Marshak's residence?
Of course not.
What happened after you told Remi to get the documents?
I was at the meet and greet, but about halfway through Remi showed up. He just did not seem all right.
When you saw Remi didn't seem all right, what did you do?
He was really fidgety and he kept pacing around. I tried to have him calm down, but he was still really anxious.
What happened? Did you do anything to try to get Remi to calm down after the meet and greet was over?
Yes, I knew he was in no position to drive and he was too incoherent to ask for a address. So I took him back to my place.
What happened on the car ride home with Remi?
I saw he had this weird box thing. I honestly thought it was a prop, and how brilliant it was for Remi to bring a prop and try to excite the crowd. I tried asking him about it, but he lashed out at me.
So just to clarify, you weren't able to have a conversation with Remi about what you thought was a prop, were you?
No, he was just not being coherent.
Finally, Ms. Croddy, did you intend for Remi to commit any illegal activity?
No, of course not. I just want to raise awareness. I didn't know he would actually go and do something illegal.
Thank you, Your Honor. No further questions.
Cross-examination, counsel.
Yes, Your Honor. Ms. Croddy, I want to start with the video you posted on February 13th. A few days earlier, you tweeted about this video that you were planning on posting, correct?
Yes, that's correct. I tweeted about the post.
You also sent an uncensored version of this video to the group chat Remi Montoya was in. Is that right?
It was by accident, but yes.
So that's a yes to my question.
Yes.
This uncensored video contained Drew Marshak's address, didn't it?
Yes, by accident, but yes.
You later asked Remi Montoya to go to Drew Marshak's home, correct?
Yes, I was about to give him the address, but he said he already had it.
In fact, you told Remi Montoya to get the documents. Is that right?
Yes. Demand information, demand evidence.
Well, Ms. Croddy, let's take a look at the exact words you used in that message you sent. If you take a look at line 12 of Exhibit B, you say, "I need you to go to that agent Marshak's," correct?
I'm sorry, let me get the exhibit.
I'm sorry, and what line was that, Ms. Jones?
Line 12?
Of Exhibit B?
Exhibit C, Your Honor.
Exhibit C, thank you. Okay.
Yes, sorry, can you repeat the line real quick? Line 12?
On line 12, you say, "I need you to go to that agent Marshak's," correct?
Yes, I suppose so.
Is that a yes to my question, Ms. Croddy?
Yes.
You also say, "Get the rest of the documents"?
Yes.
Later in line 29, you say, "We need those documents, Remi." Is that
yes.
right?
Demand answers, demand transparency.
Ms. Croddy, that's not what the statement says. It says, "We need those documents, Remi," correct?
Correct.
You also say, "You need to get into that house tomorrow."
Ma'am, I didn't think he would actually go break in. I thought meant like go in and look.
Objection, Your Honor, non-responsive.
Sustained answer shall be stricken, disregarded by the court. Ask your question again.
Ms. Croddy, you said you need to get into that house tomorrow. Is that right?
Yes, I said those words.
You didn't ask anyone else to get those documents, did you?
Remi was in the area, so I asked him.
So you did not ask anyone else, is that right?
That's correct.
Well, let's talk about the meet and greet you hosted on February 15th. Remi Montoya approached you at this meet and greet, correct?
Yeah, he was really shaken up.
You even noticed that Remi Montoya would glance at the entrance anytime someone entered or exited the cafe, correct?
I suppose, yes.
Is that a yes to my question, Ms. Croddy?
That's a yes.
Well, on direct examination, you testified that you don't know Remi Montoya very well, but you later offered Remi Montoya a ride to your own home. Is that right?
I do that to all my fans.
So that's a yes to my question, that you offered Remi Montoya a ride to your home.
He was really panicked, so yes.
2 minutes.
Well, on the way to your home, Remi Montoya said, all my problems are because of these files and stupid briefcase. Is that right?
Yes, I believe he said that.
Is that a yes to my question, Ms. Croddy?
That's a yes.
You took a look at this briefcase, didn't you?
Not very much. I thought it was a prop and I had to focus on driving.
Ms. Croddy, you saw this briefcase at one point. Is that right?
Yes, briefly at one point.
You noticed that this briefcase looked official, didn't you?
I mean, I thought it was a prop, but sure.
Ms. Croddy, is that a yes to my question, that you believed this briefcase looked official?
Yes.
In fact, you saw the outer part of a circular insignia on that briefcase, didn't you?
Very briefly. I didn't see very clearly.
Ms. Croddy, is that a yes, that you saw the outer part of a circular insignia?
Well, ma'am, I'm not sure if you mean like saw clearly or saw briefly.
Did you see the circular insignia at any point?
Yes, I saw it at one point.
Thank you, Ms. Croddy. Your Honor, I have no further questions at this time.
Thank you very much. Redirect.
Yes, Your Honor. Before I begin, may I inquire as to how much time is remaining?
Certainly.
Your Honor,
Mr.
the
Chin?
defense has 1 minute and 1 second remaining for direct examination.
There you go. Whenever you're ready.
Ms. Croddy, why did you ask Remi Montoya to get the documents?
Well, he was in the area and he's a really loyal fan.
And furthermore, when you accidentally showed Drew Marshak's address and name on the sneak peek, did you tell Remi Montoya to write down this information?
Of course not. It was an accident. Why would I tell him?
So why did you ask Remi Montoya to go to Marshak's address the next day?
Again, he said he was in the area and he said he already written the address down.
Finally, Ms. Croddy, do you believe you manipulated Remi Montoya?
No, what?
Your Honor, relevance as to what Ms. Croddy believes?
Overruled. You may answer the question. Yes or no? Do you feel you did that, ma'am?
No, of course not.
Thank you, Your Honor. No further questions.
All right. May this witness be excused. May this witness be excused, folks.
Yes,
Hello,
Your Honor. The witness
okay,
is
just want to make sure. All
I
right.
apologize,
Okay.
Your
Thank
Honor.
you very much. No problem.
At this
Now
time,
do
the defense rests.
the defense rests at this point.
Yes,
Okay.
Your Honor.
All right. We're going to transition now then into closing arguments. As we do that, everybody just take a moment, stretch. Let's give our scores just a couple seconds here to gather their thoughts. I know you all have been sitting like I have, probably not all day. So now let's get settled in. And with the prosecution, Mr. Burke, are you ready for your closing statement, sir?
Yes, Your Honor.
All right. Do you need to know any clarification on what time's left at all or anything?
No, Your Honor. I believe.
Okay, you're good to go then whenever you're ready, Mr. Burke.
Thank you, Your Honor. And before I begin, I'll be referring to exhibits A through C during my argument.
I have them in front of me. Thank you, sir.
Thank you. Lee Croddy, influencer, conspiracy theorist, puppet master. On the stage of social media, the defendant established an environment of conformity and turned Remi Montoya into a puppet. Your Honor, based on the evidence presented tonight, the court has seen how all strings lead to Lee Croddy. Tonight, the defendant is charged on 2 counts. 1, of aiding and abetting that first-degree burglary by Remi Montoya, and 2, acting as an accessory after the fact. Your Honor, the people have met their burden of proof in tonight's case. We have provided sufficient evidence to prove the defendant's guilt beyond a reasonable doubt. Lee Croddy intentionally instigated and facilitated first-degree burglary and knowingly harbored Remi Montoya. attempting to escape arrest and punishment. Your Honor, Remi Montoya was tangled up in a web of Croddy strings, social media posts, live streams, and constant personal messages, and was entrenched in a groupthink environment. Today, Mr. Montoya has told us how on February 14th, the defendant instigated his finale. As seen in Exhibit C, the defendant sent urgent and unequivocal orders to Mr. Montoya specifically. Get the rest of the documents. We need those documents, Remi, and you need to get into that house tomorrow. And so he did. The defendant not only instigated Mr. Montoya's finale with her words, but facilitated it when she provided the address of Drew Marshak's home to the group chat shown in Exhibit B. Now, when Mr. Montoya arrived at the house after receiving no response at the front door, he found a way inside because the defendant told him he had to. Line 37 of Exhibit B reads, "If Marshak won't answer us, we'll just take what is ours." Remi Montoya followed those orders. Today, the court also heard from Drew Marshak how, following an altercation over her briefcase, she witnessed Mr. Montoya say, "I had to do it." This was not a choice for Montoya. He did exactly as the defendant's strings dictated. Take what is ours. Mr. Montoya retreated then to the defendant's event where he told Lee Croddy what had transpired. Now, the defendant began harboring Mr. Montoya when she offered him a place to stay. During the ride to her home, the defendant noticed the stolen government briefcase shown in Exhibit A and saw the obvious government seal. Now, Your Honor, the defense would have you believe that the defendant's statements disprove her knowledge of Mr. Montoya's crime. However, Your Honor, you must look to the facts of the case rather than the defendant's self-serving statements to determine her true knowledge. First, the defendant ordered Mr. Montoya to obtain secret government documents. Second, the very next day, the defendant interacted with Mr. Montoya frantic at her event. Third, the defendant saw the government seal on the stolen briefcase. And fourth, Your Honor, the defendant heard Mr. Montoya tell her about what had happened at Drew Marshak's home and that he needed a place to lay low. Your Honor, looking at the facts of the case, there is no room for reasonable doubt. The defendant knowingly harbored Remi Montoya, attempting to escape arrest and punishment. Today, the court also heard from Deputy Max Bird and how, after a thorough and complete investigation, arrested Lee Croddy and determined that he was the prime instigator of Remi Montoya's burglary.
2 minutes.
Finally, Your Honor, the environment of conformity established by the defendant. Tonight, Dr. Chavez, defense counsel, was barely even able to cross-examine, utilize his psychology degree, MD, and extensive research in groupthink to identify how through long anti-government rants, the doxing of Drew Marshak, and direct calls to action, the defendant pulled the strings of her RCN fan base to turn it into a top-down groupthink environment. Now, today, the court also heard from a defense expert, Dr. Beaart, who was unable to render a final verdict on the defendant over objection, Your Honor. Dr. Beaart's lack of medical credentials and surface-level investigation further invalidate the defense's claims of reasonable doubt. Your Honor, Calcum 224 obligates you to dismiss any doubt which is unreasonable. This unreasonable doubt is exactly what the defense has tried to sell you tonight. They erroneously argued during their opening statement that Remi Montoya and Pinocchio were very similar. But, Your Honor, there are two key differences between these two puppets. First, Remi Montoya tells the truth. He's not some cartoon caricature of a liar. And second, Your Honor, Remi Montoya had many strings to hold him down, and all those strings lead to Lee Croddy. Your Honor, the people respectfully request the court render the only verdict supported by the evidence.
30 seconds.
I'm the defendant, Lee Croddy, guilty of aiding and abetting first-degree burglary and guilty of acting as an accessory after the fact. Thank you.
Thank you very much, Mr. Burke. Defense, would you like to give your closing argument at this time?
Yes, Your Honor.
Whenever you're ready, Miss Lee.
May I inquire as to how much time is remaining?
Of course you can.
The defense has 5 minutes and 53 seconds remaining.
All right, thank you very much, Miss Kim. Miss Lee, whenever you're ready, ma'am.
Your Honor, the people have told you a story a story in which my client is painted as a mastermind puppeteer, pulling the strings, controlling Remi Montoya. But Montoya is no average puppet. Like Pinocchio, Remi Montoya has cut his strings and acted as an independent individual. And tonight, the defense will show you how with every lie from the prosecution, Montoya's wooden nose continued to grow, ultimately revealing the truth. Your Honor, tonight, the defense does not have to prove a single thing. That burden lies with the people. The burden to prove beyond a reasonable doubt that Lee Croddy is guilty on 2 counts, aiding and abetting a first-degree burglary and accessory after the fact. The defense will make it clear that the people have failed to meet this burden. Let's look at the evidence, starting with the first count, aiding and abetting. In order to prove that my client aided and abetted Remi Montoya, the state must not only show that my client instigated the crime, but also that my client had a clear intention to aid and abet. But we heard from my client about her true intentions. Ms. Croddy makes it very clear that she never intended for or told anyone to break into Marshak's home or commit a crime. We also heard from Zuri O'Neill. In her testimony, Ms. O'Neill shared that although an outsider may interpret their messages to be promoting rash behaviors, the members of the group chat were all of the understanding that their passionate texts were nothing more than rants. Ms. O'Neill also shared how Croddy's words leave little room for interpretation. The state claims that my client was insinuating that Remi Montoya should break into Marshak's house if necessary, but they are reading between lines that simply don't exist. Your Honor, it is a dangerous precedent to convict my client based on assumptions about hyperboles and harmless rants that were made on social media. It would create a chilling effect if misunderstandings about what one says online are considered as aiding and abetting of someone else's independent actions. Instead of guessing what Lee Croddy was possibly insinuating, let's look at what we know she explicitly said. Directing your attention to Exhibit C, lines 34 to 35. My client clearly told Montoya, "Don't do anything I wouldn't do." Your Honor, my client is not the mastermind puppeteer that the state makes her out to be. We also learn more about Remi Montoya through the testimony of Dr. Jes Beaart. Upon examining the online communications between Croddy and Montoya and Remi Montoya's frequent participation in social media, Dr. Beaart came to the conclusion that Remi appears to be the kind of fan that acts autonomously and unprompted by the celebrity. We even heard on cross-examination, Remi Montoya admits himself that he alone was getting ready to act, even before Lee specified the next steps. Your Honor, the state has failed to prove beyond a reasonable doubt that my client aided and abetted Remi Montoya and had a clear intention to do so. Moving on to the second count, accessory after the fact. Mr. Sullivan took the stand and explained how Lee rarely took action without consulting him as well as a legal team. In fact, on the night of the meet and greet, Ms. Croddy didn't hide the fact that she was bringing Montoya to her house. Lee told her legal agent, Mr. Sullivan, about it because she was simply unaware of the crimes that Remi committed. Mr. Sullivan also testified that this was nothing out of the ordinary for Lee. He describes my client as someone who is kind, compassionate, and always looks out for her fans. So when her loyal fan shows up to her meet and greet on the verge of a panic attack, it makes perfect sense that Lee Croddy would give a helping hand. We also heard from my client how on the car ride home with Remi Montoya, she tried to ask about a briefcase that looked like a prop. But Montoya lashed out at my client. Mr. Montoya admits himself that he never told Lee Croddy that he committed an illegal act. So it was impossible for my client to have ever known that she was housing a criminal. If Miss Croddy was truly trying to hide Remi Montoya, she would have taken Remi to her secret bunker. But instead, she took him to her guest house to rest for the night. My client is not a mastermind puppeteer. She is simply an activist who wants to reveal the truth to the public. Your Honor, like the famous puppet Pinocchio, Remi Montoya was a puppet with no strings attached, a puppet that acted on its own. And like Pinocchio with his growing wooden nose, the prosecution cannot get away with their lies. The defense has pointed you to the truth. We ask that you find Lee Croddy innocent on both counts.
Thank you very much, Ms. Lee. Rebuttal from the prosecution.
Yes, Your Honor.
Whenever you're ready, Mr. Burke.
Thank you. Your Honor, opposing counsel opened their closing argument by accusing Remi Montoya and the entire prosecution of being liars. But Your Honor, that unsubstantiated claim is not supported by tonight's evidence. Additionally, Your Honor, defense counsel told us that there is little room for interpretation for the defendant's statement. And Your Honor, she's exactly right. Remi Montoya didn't do any interpreting, Your Honor. He did exactly what the defendant ordered him to do. Your Honor, the fact remains. All strings lead to Lee Croddy. Again, the people respectfully request the court render the only verdict supported by the evidence. Find the defendant, Lee Croddy, guilty on both counts. Thank you.
Thank you very much, Mr. Burke. And rebuttal from the defense. Whenever you're ready, Miss Lee.
Tonight, the state desperately attempted to pin the strings onto my client, but they failed to do so, leaving Remi Montoya tangled up in the strings that he had cut himself. But the defense will untangle these strings and turn you to the truth. The state assumed that my client insinuated that Montoya should break in, and they assumed that my client somehow knew about Montoya's crimes. But let's look at the facts in today's case. It is a fact that my client told Montoya not to do anything she wouldn't do. It is a fact that the group chat members understand that their texts are harmless rants. And it is a fact that Montoya never told my client about the crime she committed. And when we string the facts together, it is clear that the state has failed to meet their burden. We ask that you find Lee Croddy innocent on both counts.
Thank you very much, counsel. Of course, before I announce a verdict, I have to give an attorney from each team an opportunity to raise any trial irregularities. Please note that any procedural rule violations not raised at the time they occurred during the trial are now considered waived and may not be raised at this time. Of course, we dealt with some issues and irregularities throughout the proceeding, but other than those that the court has already ruled on, does any attorney wish to raise any irregularities at this time? If so, you'll have some time to let that marinate and figure out. I'll start with the prosecution. Do you have anything you want to bring to this court's attention, sir?
None from the people, Your Honor.
All right. Ms. Lee, you have anything you'd like to bring up?
None from the defense, Your Honor.
All right. Yeah, you guys did great. We're done. Championship's done. Oh my gosh. Wow, was that awesome. Okay. The scores are going to go do their thing for a few minutes or however long they need. I'm just going to try to fill a little time here and just present some commentary to everybody so that everybody who's participating and everybody who's listening in can just have such a great time. I am exhausted, but let me tell you why that is great. I am exhausted because I am feeling the same way I feel after a real trial in my courtroom, okay? I'm a dedicated felony trial court. I've been doing this for that dedication for about 12 years now. Serious violent stuff, murders, child molest, all that stuff, okay? And at the end of the day, I'm exhausted. And I'm leaning forward like this. And sometimes you may have caught my eyes closed. It's not because I'm sleeping, but I am concentrating. So I was fully engaged because the quality was so incredible, as if it was a regular trial. You know, closing my eye. I mean, you know, some people say we have too many attorneys in California. No, we can always use great attorneys. I'd love to have you swear you on right now and then give you a case and have you start appearing in courtrooms. Y'all were that wonderful. And I hope this experience, regardless of whether or not you all go into law, I think you will find this experience amazing in so many different applications in your life, okay? And again, please don't forget to thank your student advisors, thank your teachers, everybody who's contributed to this. Thank your parents for putting up with you and having to do all this, okay? And if there's any parents listening, I'm sure you're like many parents when we do this in a courtroom and you all are in the audience. I find over the years that you all sit there just with your jaw dropped down the ground going, oh my gosh, who kidnapped my kid? Because they're not a kid, they're an adult. I can't get them to clean up their room and do chores, but Lord, they're acting like mature adults. And so parents and everybody have so much to be proud about in regards to what they witnessed here. And I'm sure when our scores come back, they're going to have some wonderful things to say. I don't have any critiques, because I'm tired. But I think both of you probably, demonstrated probably the concept, and I explain sometimes to new attorneys. You come into courtroom with a toolbox. Your toolbox contains your facts and your knowledge of the evidence code, okay? And your job is to utilize every tool in that toolbox and don't leave any behind. You all did that. Regardless of my rulings and what you think about it, whatever. I just hope when the day is done, I came into this and I was explaining to the directors of CRF that, the pressure was on me and I was nervous because I was lucky. I didn't have to score you, so I could sit and concentrate and not do two things at the same time. But I wanted to make sure I created the best forum for all of you to shine. Hopefully I did. And again, that's my job, to be even-handed, not to be one side or the other, but more importantly, provide a forum or a theater in which for you to act. Finally, in kind of drawing on the Pinocchio and the puppet and the strings analogies that both of you used, it's often said that courtroom work is theater, in the sense that you are telling a story and you have to persuade folks by telling your story. And so I guess I watched a puppet show and I was in the audience. And as a result of that, I am now going to tell you what I thought about the performance and give you a verdict, okay? But it's a verdict. It has nothing to do with who won or who didn't win, but you know that. I'm sure you've been told many times, okay? So hold on, I wrote this. Let me see, I got scribbled some notes here. Okay, here we go. All right. The court, having heard and considered all the evidence in this case, assessed the credibility of the witnesses as well as applied the law as given. The court, in the matter of the people of the state of California versus Lee Croddy, finds the following. Not guilty of the crime of first-degree burglary, a felony, to wit, violation of section 459-460 subsection B of the Penal Code of the state of California, as charged in count 1 of the information. Guilty of the crime of accessory after the fact, a felony, to wit, violation of section 32 of the Penal Code of the state of California, as charged in count 2 of the information. With that, it looks like I do have some scores available. Feel free, whoever wants to chime in, give a few words of commentary as they are compiling all the scores. Mr. Schwartz, I don't know if you have a couple of words of praise or encouragement or just a commentary you'd like to give, sir.
I do. First of all, I could not be more impressed with both teams, right? I mean, they were just super impressive. And what I was especially impressed by was everyone's composure, especially when Judge Jensen was interrupting and asking questions, and the ability to, one, respond on the fly and then shift back into arguments or questions was terrific. And I can just tell you, as an attorney who has tried cases in front of Judge Jensen, he's much kinder to me than he was to you folks. So anyway, I could not have been more impressed by both teams tonight.
Well, I hope I didn't come off as being mean to you all. There's a method to my madness. You're at this point here in the finals where you've had, different judges, different styles and what have you, and you kind of get into routines and you kind of get into, I don't want to say ruts, but you kind of get into a groove. And I think as Mr. Schwartz indicated, your ability to be kind of, and trust me, I've been on that side and done the competitions in law school and what have you, but your ability to deal with an interruption or a stupid question or something that's completely irrelevant, answer it with professionalism and respect, but then get back to it. is truly a skill that everybody had. So, Mr. Guevara, anything you might want to say, sir?
Yes, Your Honor. I also agree with my colleague, Martin Schwartz. I too were very sympathetic to our pretrial lawyers, having argued many times before Judge Jensen, and he also asking me questions in a similar fashion, and particularly about some of the similar issues about Miranda and custody. So I thought that was very realistic. I was really super pleased with our pretrial lawyers, both of them, the way that they hung in there. They clearly understood the case law. They as best as they could, given the facts, which I thought were a little lopsided, maybe favoring the people, but nonetheless, answering in a clear and articulate manner the court's questions. That is not an easy thing to do, and that is much different and a distinctive talent than actually the trial lawyers themselves. So kudos to that. I thought it was great. I also want to thank everybody this year. Having served for many years on our board of directors and a past president of CRF, this was a very unusual year. To the teachers out there, the parents, to our lawyer coaches, and all the students, having to deal with Zoom, having to learn the materials and work with your coaches with Zoom and not being physically present was just an additional barrier that you overcame and met. So that was a tremendous thing. This was not an easy task to do, to prepare and work with this kind of material and do it online without actually physically rehearsing. And many times we actually take and we rehearse, having coached myself, we go to a courtroom and we actually rehearse and we go back and forth and learn all the roles. And so this was very difficult. So no matter which team wins tonight, everybody, as I said before, should be congratulated. You were phenomenal. To those seniors who are graduating, who I have a feeling I recognize some of you having participated in past years for the mock trial, congratulations. I hope that this experience has taught you a lot about criminal justice system, the rules. It's much different than you see on TV or some of the talking heads. And in particular, you've learned a newfound respect and an understanding about our third branch of government, who, unlike other branches of government, is not ever in a position to tout themselves as to fairness and what they really do for our American society. So again, congratulations. For the performance again of all of our trial lawyers, very, very good. In particular, I thought it was, you really understood the evidence objections. I'm sympathetic also to our judge tonight. They really put you through his paces. In fact, it was probably worse than a real trial, going back and forth. So I think although we're on Zoom, let us give a thumbs up or a round of applause to our presiding judge tonight, because he really performed in a Supreme Court manner, particularly with having to go back and forth with regard to figuring out the times. Students, if you ever thought about Solomon being a judge, you saw it tonight, trying to figure out the times and work with you. So with that, I'll turn it over to another one of our colleague scorers tonight for their brief comments. So thank you all. And whatever team goes on, Orange County will definitely be incredibly represented in the state finals. So thank you again, all. Juniors, sophomores, I look forward to seeing you again participate next year. This time I'm hoping back at 700 Civic Center in our Superior courtrooms. Thank you.
Thank you. Mr. Yoder, would you have a couple seconds?
Absolutely. It's late, but I think we're all waiting, so we can wait a little longer. It was fascinating watching this on Zoom because it was so much easier to see your facial expressions, where it's much harder in a courtroom. And I must say, I was so impressed with the way all of you assumed the role, and not only trying to perform and recall what you're supposed to say, but then, as you all know, having done this, it's fluid. You can't script it out. Things happen. But just watching the facial expressions and the control of the emotions was just fabulous. I mean, kudos to all of you. Very good job. You experienced, especially Burke and Ms. Ives, during the examination of Dr. Chavez, a great example of what trials are all about. They never go the way you expect. Things happen. And I think one of the real differentiating factors amongst trial lawyers is being able to respond when things don't happen the way you expect them to. And both of you are, I was so impressed the way you handled it. Having the conversations back and forth with a judge who lets you make your pitches, who asked good, tough questions, you were able to respond. And indeed, on so many of the objections, saw that time and time again. So finally, though, I will also just commend the clerks. What a difficult position to be in. And I just was just admiring you, sticking to your guns, doing it in a civil way, a professional way, not taking it personally. I mean, it was so comforting to see, talented high school students who can be argumentative, who can be passionate as advocates, but who can do it in a civil and professional way, which would always get us to a much more just and right result. So kudos to you for that.
Thank you, Mr. Yoder. Mr. Bataille, if you have a moment.
Thank you, Your Honor. It's very clear to me why these two teams made it to the final round. You were both absolutely excellent. I can tell you part of my job is to interview graduates from law school who want to become prosecutors. And I happen to be doing this all this week. And some of you did a much better job than many of the applicants that we put through having to do a closing argument before we decide if we're going to hire them. So congratulations, you did great. If you will allow me to give you two pieces of advice, because one of you is going to represent our county moving forward, and either one of you are going to make us proud. You're going to do a great job. The suggestion that I'm going to make to you is be aware of your audience, especially when you're raising an objection, right? So if you say objection, don't right away jump into may I be heard. There's a big likelihood the judge may grant your objection. So just say objection and wait, and just be aware of your audience. Also, just because there may be an evidentiary reason for you to raise an objection, you may want to think about it and say, is it beneficial to my client to raise that objection? Other than that, you all did great. You did excellent. The second point I want to just mention to you, this is a wonderful and noble profession. I hope all of you will consider going to law school as you go through college. It's a noble profession because it's a profession where you are advocating for your client. You're taking an opposing position to opposing counsel, but it's always done in a professional way. It's always done when you're done with the argument, you shake the hand of your opposing counsel and you treat them with professionalism and with respect. So it's good to be passionate, but always draw a line between making an argument about the fact and becoming personal. So there is a difference between saying the witness lied versus the attorney lied, right? So be careful about that when you're making your argument, right? You can address the facts and the law and the argument, but don't ever make it personal as far as the opposing counsel. Having coached mock trial for 8 years and having been part of this for the last 23 years, I am so proud. And I hope your mom and dad and your teachers are watching because they should be so proud of you, so very proud of you. So congratulations to both teams. In my mind, there are only two winners. There's not going to be a loser here. Thank you very much, Your Honor.
Thank you very much. Mr. Judge Delaney, you had the pleasure and the honor of doing this last year, so I thought maybe you might have some thoughts.
Thank you, Judge Jensen, and great job, Judge. You did a wonderful job. You were challenged just as much as they challenged each other. They did a great job, and watching the professionalism and how unflappable you all were. There's so much talent in this screen right now. I just can't believe it. Honestly, the future of the profession and the future of our justice system is in good hands. I hope you all go, or at least some of you go to law school. But if you don't, understand, I know that this was difficult and it was more difficult than typical for those of you who have done this before and you're dying to get inside the courtroom. But we are in discussions now about how this format will remain in the justice system. So you already are ahead of the game in developing skills that our current lawyers don't have, our current judges don't have. And you mastered them tonight. You all mastered the art of persuasion, engagement, and advocacy virtually. So congratulations for that. Again, our future, or the future of our profession and our system is in strong hands. I agree with everything everybody said. I'm just going to add one thing. This has been one of the best uses of themes by both sides I have ever seen. The prosecution theme, I was wondering where that was. It hadn't happened in a trial yet for me. There it was. The defense took it and used it to its advantage. Awesome. Prosecution stuck with it and still made it really effective. Awesome use of themes. You'd be shocked at how many attorneys come to trial and do not have a theme at all, much less an effective one. Both sides did that tonight equally well. You're to be congratulated. You should be very proud of yourselves. Thank you for an entertaining, productive, and tremendous trial. I really enjoyed it. Thank you.
Thank you very much. I appreciate, again, all the time and effort and the input that our scorers have given to this process and their comments to you all. Just a couple quick comments, and then I'll indicate to you all who the winner, I guess, is going to be in this particular competition. So, yeah, I agree with the comments. I'd love to have you all in law, but you don't have to all be in law. This is my fourth career, so I stumbled into law with no intention of ever being a lawyer. So you talk about a different path that led me here. I got out of college and I went into the business world, and I worked for 2 Fortune 500 companies, and then decided I wanted to go back and get an advanced degree, and it was between my MBA or my JD. And at the time, I knew I could get my JD in and go back into the business world, which was my full intention of doing that. However, I had an opportunity. We didn't have this kind of competition in high school, but I had an opportunity in law school to do an internship with the district attorney's office here in Orange County. I was very fortunate to be able to do that. And for me, the minute I walked into a courtroom is the minute I knew that's where I wanted to spend the rest of my career. And I've never looked back on that decision whatsoever. And the fact that I have been in the legal arena now for almost 30 years, and when I say 30 years, it shocks me because it's gone by so fast, basically leads to this final point. I truly believe whatever y'all end up doing, and I know y'all are going to do some wonderful things, if you can follow your passion, because if you love what you do, the time will fly so fast. There's a correlation between how fast time flies and how much you enjoy what you're doing. With that then, ladies and gentlemen, I have the envelope here, okay? Again, wonderful presentation. I am proud to announce that the winner of this competition is University High School. Congratulations to you all.